Mr. Semenya.
Chairperson, Commissioners, good morning, and we are to hear the evidence of Advocate McAdam this morning.
Yes. Mr. Ban, I take it you are going to lead Mr. McAdam.
Thank you, Chair. Good morning
Yes.
to you and fellow commissioners. May I proceed?
Yes, let me swear Mr. McAdam in before you proceed.
Thank you.
You can sit, Mr. McAdam.
Thank you,
You can
Madam
take
Chair.
your oath seated. Please state your full names for the record.
Raymond Christopher McAdam.
Are you going to take an oath or affirmation?
I'll take an oath, Madam Chair.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you, Mr. Advocate McAdam. Mr. Ban, are you witness?
Thank you, Chair. Good morning, Advocate McAdam.
Good morning.
You received a Rule 33 notice from the Commission dated 14 October 2025.
That's correct.
We don't have to go there now. Essentially, and in due course we'll deal with the pertinent points in the notice, but essentially it deals with certain points or matters raised by a certain Mr. Kaji in relation to the late Mr. Timol, correct?
That's correct, yes.
And a statement was prepared on your behalf to deal with those matters and other pertinent issues. Is that correct?
That's correct.
And that statement is dated 3 March 2026.
That's correct.
Chair, I will give you the pagination number in a moment. 1390. Page 1390 of the Commission's bundle. You confirm that statement under oath today?
Correct.
And that is subject to certain typos that you've asked me to bring to the attention of the Commission. The first is at paragraph 116,
Correct.
bundle page 1425. And do you have your statement in front of you?
I do. I've turned to, it's on my page 30, and it's the second paragraph from the top.
Thank you. And the correction is the deletion of the word prosecute in the first line, and you want to substitute that with deal with. Correct?
Correct, Madam Chair.
The next small amendment is paragraph 120, Commission Bundle 1426.
Correct, Madam Chair. I have turned to paragraph 120. It appears on page 31, and it is again the second paragraph from the top.
And in the second line, you just wanted to delete the word prosecution, correct?
Correct.
And paragraph 6, sorry to take you back, there's a missing word there.
That's correct.
And
Page 1 that I have.
yes, and Commission Bundle page. No, bundle, paginated bundle. It's page 1. Paragraph 6. There's a missing A to respond to A Rule 33.
Yes, and also I wrote in notice as well, because that was
Notice,
also
yes.
omitted from the typed version.
Perfect. And subject to that, you confirm the statement under oath, as you've said.
That's correct.
If we can then just go very briefly through certain paragraphs of the statement to be highlighted. You set out background to your appointment and career in paragraphs 4, 5, and 6
That is
of
correct.
the notice. And very briefly, can you just tell the Commissioners what is contained therein?
Madam Chair, I joined the Department of Justice in 1980, having obtained a BA LLB, and as a prosecutor. At that stage, there was no NPA, so the prosecutors fell directly under the Department of Justice. In February 1992, I was appointed as a Deputy Attorney General in the office of the then Attorney General Natal. In 1998, I was appointed by Mr. Nguka to then head a investigating directorate focusing on the political violence in KZN. I served in that capacity. Sorry, Madam Chair, I just made one mistake. After being an Attorney General, I then joined the TRC for a short period, firstly dealing with witness protection, and secondly then doing specified investigations as directed by Advocate Demisa Nsebeza. I was then taken out of the Truth Commission in order to head the investigating directorate into political violence, which I started serving in 1998, and my last service there was in December 2000. What happened is that in between, the NPA had amended its act to give itself an investigative capacity, the Directorate of Special Operations, or the Scorpions. Now, the NPA Act provided that all the preceding investigating directorates would dissolve and their work would then be absorbed into the Scorpions, so they wouldn't continue and run parallel with the DSO. And then I was invited by Mr. Ngluka to take up an appointment in the DSO head office, which I did in January 2001. Almost immediately, however, I was instructed by Mr. Ngluka to take over the Department of Justice Witness Protection Program. This was due to two key witnesses in the cases against Pagad being murdered in their safe house, and there was a concern as to the safety of the other witnesses and whether witnesses would be deterred from coming forward if their lives were put at risk when they're under protection. And then in March 2002, I was taken back into the DSO. And at that stage, I was appointed to head a head office component called the Special National Projects Unit, SNPU. Now, that component had two portfolios. The first was to take over the TRC cases from a unit that Mr. Ngluka had set up in 1998, but had dissolved in 2000. So I was to continue their work, but at the same time I was to do organised crime projects where it was considered inappropriate to refer those projects to the regional DSO officers. I served in that directorate until June 2003. What had happened is in March 2003, Mr. Ngluka had set up the Priority Crimes Litigation Unit, the PCLU, and that was set up to manage investigations and prosecutions into crimes that are specified in the presidential proclamation that created the unit. Now, what happened is Mr. Ackerman SC was appointed as the special director and head of that unit. And while I was still at the DSO in May 2003, I was approached by Mr. Ackerman inviting me to join his newly established unit, which I did. And then I joined the PCLU in June, and at the end of May there was a meeting with Mr. Ngluka, Mr. Ackerman, myself, and then Dr. Ramahiti. He was the Deputy National under whose portfolio the PCLU fell. The MPA has a national director and then 4 deputy nationals. Each deputy national manages a specific portfolio. For example, asset forfeiture, the DPPs, where 90% of prosecutions take place. And then you had also the component that deals with civil claims against the NPA. And then Dr. Ramahiti was in charge of all the special units that was set up by Mr. Ngluka. We had the PCLU, but we also had then the SCCU, which was doing serious commercial crime cases, and we had SORCA, which was doing sexual offences against women and children. So all of those fell under Dr. Ramahiti. And at that meeting, it was decided that all the TRC cases would then come to the PCLU, would be managed by the PCLU, reporting to Dr. Ramahiti, who would report to the National Director.
Thank you. Can we then skip to paragraphs 21 and 22, and if you can take the Commission through
Certainly, Madam
those
Chair.
very briefly.
Is it 21 is the first paragraph?
Yes, 21.
I have it on my page 4 in the bottom paragraph.
1396. No, sorry, paragraph 21. I think you can proceed in the meantime.
Certainly. Madam Chair, on the 2nd of May 2003, this is while I was still in the DSO and before the TRC cases had moved to the PCLU, Mr. Kaji came and saw me. He introduced himself as being the nephew of Mr. Ahmed Timol, a detainee who had died in detention in 1971. What he did is he informed me that he had done his own investigations into his uncle's death. Firstly, he informed me that the inquest record had been destroyed in the magistrate's court. That's because of archive instructions which say if after a certain period there's no new evidence which justifies a prosecution, they may be destroyed. This was due to the magistrates complaining that they had inadequate space in their offices to keep this huge volume of documentation. So it wasn't destroyed to conceal anything, it was simply to comply with archive instructions. He also informed me that there was a former police officer, Mr. Gloy, who had been involved in the death of his uncle, that Mr. Kaji had approached him and the police officer had said, I've got nothing new to tell you, you must go and read the inquest record. And lastly, he also had some documents that with him, including, I think, Mr. Timol's mother's statement as a victim at the TRC and some reports by co-detainees. But what he emphasized was that he had information that there was a journalist, Ivor Powell, and another policeman who was involved in the Timol matter was a Sergeant Rodriguez. And the allegation was that the daughter of Rodriguez had gone to Mr. Powell and told him that her father had given her a version of the incident which differed from the version that was put at the inquest. And he, emphasized that it would be important to go and see Mr. Powell if he can confirm that disclosure made to him. And I agreed that was a very important thing to do. Now, I must explain the difference between the police and the DSO. A police officer on information can open an inquiry and simply conduct an investigation and submit the docket back to a prosecutor who can then make a decision. Whereas with the DSO, it's regulated firstly by Section 7 of the MPA Act, which requires that an investigating director must be appointed. Now, Section 28 of the MPA Act requires that an investigating director must authorise all the prosecutions, all the investigations. So a member of the DSO can't, on his or her own initiative, start an investigation. Section 28 further applies that if the director authorises the investigation, the director has to appoint the persons to conduct it. Section 28(1)(c) requires that if, after authorising the investigation, additional crimes are committed, then the investigating director has to authorise an extension of the investigation. Only the investigating director can decide to prosecute. And the law required that deciding to prosecute must also have the consent of the DPP where the crime's been committed. So in this matter, I couldn't, on the basis of what Mr. Kaji conveyed to me, immediately start an investigation. My responsibility was to request the Chief Investigating Officer of the DSO to then do an informal inquiry to gather information which would enable me then to apply for an authorization from the investigator. With the TRC cases as well.
Sorry, is that what you refer to as the Section 28 application?
That's correct. So And what was also a prerequisite, the DSO required of me to submit a national project proposal dealing with the TRC cases, which had to include a budget. And the project proposal and the budget had to be approved before any investigations would be authorized. What I did then is on, it's just
5 May, paragraph 22.
22, sorry, I skipped. So what I did is I then wrote to Mr. Lees 2 days after I'd interviewed Mr. Kaji, and I asked him not only to follow up the allegation of the disclosures to the journalist, but also to speak to Advocate George Bezos, who had represented the family at the inquest, to see whether there were any TRC records relating to fellow detainees who may well have been able to document torture. And I also asked that he approach the chief pathologist to give us an opinion on the original medical evidence. I just need to know, I do have annexes that are attached to my statement dealing with this matter, if it's necessary to refer to those.
I'll take you there if it's necessary. For the moment, I think references to AD2 at 1428 of the Commission's bundle. And in particular, if you can 1428, 1428. And in particular, if you can look at the second page of that memorandum, paragraph 4, Commission Bundle 1429, you then asked him to focus the investigation on certain areas, correct?
That is correct, yes.
And can you just identify those?
I must just find this again. So I apologise, Madam Chair, I must just page through to the
second page of AD2.
Of AD2. Oops. Madam Chair, I also apologise, I have arthritis, so I battle turning pages.
Yes, no, take your time, Mr. Advocate McAdam.
Certainly, I now have the correct page.
Yes, and paragraph 4, you required further investigation into certain areas.
That's correct.
And very briefly, just go through them.
The first was to interview Advocate Bezos. He was the lawyer who represented the family, so we believed he may well be able to supply useful information. Then he must interview Ivor Powell, the journalist. And then I asked, we had appointed 2 former TRC researchers on contract to help retrieve archive material and to also draw our attention to evidence that had emerged at the TRC. So I said, talk to those researchers, see if there's additional material that they could source for us. Then an important thing is, I want to see if the policemen who were involved in the Timol matter were not implicated on other crimes, because obviously we want to look at all these crimes, and you could then establish a modus operandi rather than looking at one individual case. And then I said, if there were any ex-former detainees who were available and be prepared to be interviewed, they could be interviewed. And then lastly, I said, once he got all this information, is to request an opinion from the Chief State Pathologist.
Yes, thank you. And can you very briefly, just to assist the Commission, outline the Section 28 process? Just conceptually, what does it involve? How restrictive is it? Have you had cases thrown out or a Section 28 refused?
Yes, Madam Chair. As I said, everything is micromanaged by the investigating director. So the prosecutor, who's in the DPP, has an unfettered discretion. If a police officer says, I've received information from member public, that prosecutor can straight away request the police register an inquiry and start gathering information. Now, that cannot be done because, as I said, Section 28(1)(a) requires the investigating director to personally authorise the investigation, and he does that on the basis of the material that you put before him and under cover of a report where you also set out all the legal implications. And then also, because the DSO is part of the NPA must pay for all the investigative costs, unlike the police, where they have to bear their own investigative costs, and the prosecutor just gives guidance as to what evidence needs to be gathered. So That was also complicating because now, as a Deputy Director of Prosecutions, I also had to manage the budget of investigators. But we go now to 28(1)A, which is where it requires the investigating director to authorise an investigation, but it gives him a discretion. He's not obliged to declare an investigation in respect of each matter that's referred to him. The only exception to that is section 28(1)B. If the national director himself or herself refers a matter to the DSO, they don't have a discretion, they must investigate. Then we have 28(1)C, which is where the investigating director must authorise any extension of the original investigation. So if he'd authorised the death and detention of Mr. Timol, but we see 3 other cases that are linked to it arising out of my investigation, then we have to get him to authorise that before we can even start investigating those other matters. Then there's another provision which says the investigating director appoints the people to conduct the investigation. He must authorise specific persons to issue subpoenas if you want to compel a witness to provide you with information. And then finally, I think this falls under section 24 of the MPA Act, that if he prosecutes, he must have the consent of the DPP. So this is a very cumbersome technical process, which is unlike how it works with ordinary prosecutors and police officers. And particularly when the DSO's mandate was serious organised crime, there you'd want to move quickly and fast, and that's not possible where everything has to go to the investigating director, because only one investigating director is appointed for the whole of the DSO, and they had regional officers in the Eastern, Western Cape, KwaZulu-Natal, Gauteng. So that's the legislative process that had to be followed, not only in the Timol case, but in every other case that we required the DSO to investigate.
In the Timol case, before applying under Section 28, you required the further investigation to be done that we've gone through in
Yes.
82. Is that correct?
What I'd rather refer this to, not an investigation, but inquiries. Because what we said is, although the investigator authorised it, he must have facts before him. So I said you can gather information from like open source or people who are willing to talk to you, which would not constitute an investigation, but that provides the evidential material which is then placed before the investigating director. Now,
As part of the Section 28
that's correct. What
application.
one would do is, I would, as a deputy, write an application. I would attach the evidence that we had obtained under cover of an affidavit from the investigating officer, and if there were legal issues that were raised, I would deal with that. It all goes before the investigating director. If he's satisfied, he authorises. If he refuses, then that's the end of the matter. It may be that to say it's not enough now. See if you can come up with more, and we can look at it at a later stage. But when it comes to legal challenges, at this time, there hadn't been a legal challenge. But in 2004, there was a legal challenge to the authorisation of a 28 investigation on very serious corruption charges. And the SCA then declared that investigation unlawful because they found that there was non-compliance with Section 28. And then the SCA said they are mindful of the need to move quickly and effectively on serious crime, but that it's not at the expense of legality. You must fully comply with Section 28, and when you don't, your investigation is invalid. So this is why we didn't have the judgment at the time, but I knew that we could anticipate challenges. That's why I wanted to have these applications watertight. So if we were challenged, we could demonstrate that we had acted lawfully.
Did you ever reach the stage of a prepared Section 28 application being submitted in the Timor case?
Correct, Madam Chair. I had already started looking at TRC cases in March 2002, and we had opened 41 files, not only on matters requiring investigations, but other issues relating to the TRC. For example, the TRC reported that 477 persons had disappeared, their bodies never been recovered. Now, that was brought to our attention. that we would see what we could do on that, because it was a very big concern, particularly for the poor victims. And I had then worked on certain cases, and I was very fortunate that I had the Motherwell bombing case, the Pepco 3 case, the Mama Lordy 10 case, and 2 other cases, and there you already had significant work that had been done. In the Motherwell and Brown and Ngalunga matters, we had a full police investigation, a full criminal trial, and a full amnesty process. So I said on those cases, there is more than enough to justify an investigation. So I drafted applications on all those matters, as well as I concluded my project proposal and my budget. So that was all submitted to the investigating director, I believe, in May 2003.
And I might have missed it. Was the Timol case submitted with those?
No. You see, that was one where we had information that we'd have to start from scratch. If, for example, Mr. Lees had interviewed the journalist Ivor Powell, we could declare it on that basis. But what we had is that the inquest was not available, and the policeman that was involved had said he stands by his version. So that's why I didn't apply for that. I wanted Mr. Lees to first comply with these directives of mine, so I could then bring a proper application. Okay. But also, this matter was brought to my attention only in May 2003. Now, in the Brown and Ngalunga and the Motherwell case, I believe that I would have very strong grounds of prosecuting a security branch general who'd been intimately involved in the murders committed by the security branch. And there was a full set of evidence. So that was our priority, and also I'd emphasize limited resources. I only had one advocate who was available to me, and we had a very small team of investigators. So we had to prioritize our investigations. We could not address all these 41 matters at the same time. And I believed if you could effectively prosecute and get a conviction against a police general, this would have a very positive effect, that people who were deciding to sit the process out would then come forward and talk out of fear that they'll go the same route. And
okay, just on the Timol matter, did you reach the stage where you submitted a Section 28 application?
No.
No. And why was that?
As I said, I was waiting for Mr. Lees to comply with these directives.
Okay. If we can go to paragraph 25 of your statement, can you take us through that?
Correct, Madam Chair. This is an audit that I did while still at the DSO, shortly before the PCLU came into existence, and I was then appointed to the PCLU.
And
it's Annexure AD4.
And that was on the 15th of May 2003, as you say.
That's correct.
And Annexure AD4, if you can very briefly take us through that.
Yes.
Chair, Commission Bundle 1457, as I have it.
1457.
1457. Are you there, Mr. McAdam?
Yes, I am. If you look...
Yeah. You don't have to go through the detail, but just take us through the gist of what was said.
Okay. Heading A were cases that we believed could be prosecuted provided further investigations were conducted. They are listed. We had 7 of those matters. Then we said if we successfully prosecute in those matters, we believe that would open up prosecutions on the murder of the activists that were referred to as the Pepco 3, and it would also open up the prosecution of the policeman responsible for the killing of the activists in the Craddock 4 matter. Then what we said is that is Category B. Category C was new cases, but we believed that there would be prosecution potential on those matters. Category D is high interest matters which require attention irrespective of the nature of the evidence. So on those matters we believed even if you did not prosecute, you would have to justify why you're not prosecuting. And then we move to E is representations to investigate specific cases. And there you, well, case number 1 is the death and detention of Mr. Ahmed Timol.
Under category E.
Under category E and as the first case.
Yes. If we can then deal with paragraph 26 of your statement.
Certainly. Correct, Madam Chair. That is dealt with in my annexure AD5.
Perhaps just take us through the content of paragraph 26 and then we'll go to AD5.
I've got AD5 in front of me. It's correct. I then submitted an application for authorization of investigations in 6 matters, and I also submitted my national project proposal, and that was all done on the 22nd of May, 2003. And again, this was done as a member of the DSO because I'd only joined the PCLU in June 2003.
Yes, I don't think anything turns on it. You said 6 matters, your statement says 5. Nothing really turns on that. But
Correct. I apologize, I didn't do my mathematics when I did my statement, but it is 6, you can see it.
Okay.
Listed 1 to 6.
And that's at 1462 of the Commission's bundle. If I can then ask you to please take us through paragraph 32.
Okay, certainly. As I said, these had been submitted to the investigating director already on the 22nd of May. Now, we could not proceed on any of these 6 matters there, specified there unless we had those authorizations. So what happened is we had no feedback as to whether my project proposal had been approved or whether my budget would be approved. So this led to Mr. Ackerman, who was at that stage the head of the PCLU, and I going to see the investigating director, Mr. Ledwaba. That took place on the 15th of July 2003. And then at that meeting, Mr. Ledwaba informed both of us that he had decided that all the TRC cases must be taken away from the DSO, they must be referred to the police. And he was very firm on that. He wasn't prepared to consider any, counter proposals from us, and he requested that his instruction be reduced to writing as well. So that put an end to the DSO investigating all matters that we had identified, not just the 6 that were in the absent Section 28, because in the other matters that weren't, we wanted to continue gathering information so that we could get Section 28s on those as well. But everything came to an end. Nothing further could be done. The PCLU is not an investigative agency, so we depend on either on the police or the DSO to investigate matters. Our sole role in investigations is simply to give guidance to those matters, which is a normal thing where the prosecutor says, these are the witnesses you need to obtain statements from. They must canvass these issues with them. So essentially, that brought all the TRC cases to a hold, except for some 400 dockets that the police had investigated before April 1994 against the military wing of the African National Congress. Those dockets were under the control of Mr. Fick SC, a very senior deputy in the Pretoria office. So because those were police investigations, they were not affected at all by Mr. Ledwaba's decision.
So those stayed with the police?
That's correct.
And the Timol matter was amongst those that was then transferred to the police?
No. What happened is Mr. Law made it clear he's not going to investigate. We have no choice. We can only go to the police. It's the only other investigative agency available to us. So I don't know if you want to go ahead to my engagements with the police now or the other things.
I think for the moment I just want to know where was the Timol matter at that stage?
It was one of the
been
DSO
transferred?
matters that we had flagged as wanting further evidence to be gathered to lay the basis for a Section 28 application.
So not yet transferred to the police?
No.
Okay. Can we go to paragraph 43 and 44 of your statement?
Yes, I have it.
If you can take the commission through that.
Certainly. Perhaps may I just intervene, because this is now dealing with February 2004, but what happened is, as a result of the meeting with Mr. Ledwaba, Mr. Ackerman and I then met with Commissioner De Beer. He was the divisional head of the detective service of the police, so all the detectives fell under him. And we asked him, can the police now take over the cases which the DSO had declined to investigate, and add it now to the ANC cases which the police already had. And there were meetings and requests to put our request in writing, but we got a response, I think it was September 2003, from Commissioner De Beer, saying that having discussed with the National Commissioner of Police, they would not take over those former Scorpion cases unless either Mr. Ackerman or Mr. Nguka went to the President and explained to the President why the DSO was not doing its work. The police letter alleged that when the DSO was set up, it was agreed between the police and the DSO that the TRC cases involving security forces would be the responsibility of the DSO, and the claim was also that the police had transferred police officers who'd previously worked on those matters to the DSO in order to give them that capacity. And then clearly neither Mr. Nguka nor Mr. Ackerman did go to the President.
Yes.
I mean, Mr. Ackerman would not get an audience with the President, and Mr. Nguka would have good reasons for not doing so. So that explains now why these cases were not then taken over by the police, and everything remained in limbo.
And that's dealt with in paragraph 36 of your statement and AD 11. We don't need to go there for present purposes. If you can then advance to paragraphs 43, 44,
certainly,
and perhaps also 45, and just take the Commission through those.
Yes, certainly. In February 2004, I received a fax from Mr. Kaji asking for feedback on the inquiries that I had initiated. And then on the 25th of February 2004, I informed Mr. Kaji that the allegations relating to Mr. Powell had been followed up, that Mr. Powell had denied all knowledge thereof. And I also confirmed that Mr. Kaji had given me certain documents when I met him, and I asked him to give me one document which I think I may have misplaced, and any other documents. The reason I asked him is because he had informed me he had done his investigation. He was an employee of the state, so it wasn't an indigent person who had not any means to do this. And I never got a reply to that letter. Then if you want me to move now to 45.
Yes.
So now what happened is, as far as the DSO was concerned, I've already said that if the national director refers a case to the DSO in terms of section 28(1)(b), the investigator has no discretion. He must investigate. His only discretion is on the conclusion of the investigation to decide whether to prosecute or not. So his hands are tied. He must investigate. Now, the reason is that obviously the national director would not refer a matter to the DSO unless there were very valid grounds, whereas on Section 28, it could be a request from the member of public or, say, an inexperienced member of the DSO. But that's why it's mandatory. You cannot not investigate if the national director tells the investigating director to investigate. So what happened there is that, in fact, in December 2003, Mr. Imuka did refer cases to Mr. Ledwaba, including some of the cases that had been in my application, which I had submitted in May 2003, and additional matters which he then referred in February 2004, the last referral by Mr. Nluka was done a day after I had replied to Mr. Kaji. So I was then very optimistic. Now, Mr. Ledwaba would agree to now take over the responsibility, and then we could put the cases back in the DSO.
Yes. And you say in 45, shortly thereafter, you were assigned to duties that took you away from TRC matters. You had to deal with an international nuclear weapons syndicate case and numerous other responsibilities, correct?
That's correct.
Yes. Can we pick up then at paragraph 53 of your statement and perhaps just deal with 53, 54, and 55?
Yes, certainly. Madam Chair, the background to this is that in December 2005, the Parliamentary Portfolio Committee on Justice approved amended NPA policy guidelines dealing specifically with TRC cases. And then those guidelines made provision for the fact that the PCLU in the execution of its duties would be assisted by a single member from the police, the NIA, that's the forerunner of the state security agencies within the National Intelligence Agency, the Department of Justice. Why we listed Justice, they were the custodian of the TRC records that were stored in the state archives. And then that's 3 departments. I think there may have been a couple more that I can't remember at that moment unless I look at the proclamation. But it's not important as to who these departments were. But the fact is now the matters could be, oh yes, and the DSO was also listed as a department which had to assist the PCLU. So I believe inserting that provision placed a statutory obligation on both the police and DSO to investigate TRC cases. They could not decline to do so as they had done in 2003. So I believe that properly implemented, this would resolve our issues. And then we have the police and the DSO working jointly. So you can divide the labour, and sometimes it'd be better for a policeman to deal with the matter, sometimes it's better for a scorpion. So on that aspect of the guidelines, I've regarded it as a very good step. Now what happened is, in terms of the guidelines, Mr. Pokoli had become the national director. He appointed Dr. Ramahiti as the chairperson of this. There is confusion. Its technical name, I think, was the but it became, everybody referred to it as the task team. So I think for ease of reference, I'll just talk about the task team. It did have another name officially in the Gazette. But Dr. Ramahiti was the chair of the committee. Then Advocate Ackerman was the senior member of the PCLU who was represented in the matter. And then when I had been assigned the other duties, Mr. Marga, a senior state advocate, had taken over my responsibilities and he was working on the matter. So there again, I was not part of the process except for attending 2 or 3 meetings of the task team when Mr. Ackerman was either not available or he wanted me to be present and to brief the task team on certain aspects. But what happened is on the 5th of June 2008, there was a meeting between Dr. Ramahiti, Mr. Ackerman and myself. And that, what was discussed there and what was decided is set out in AD 18 of my affidavit. I don't know if you want to...
no, it's not necessary for present purposes.
But then...
Just to help the commissioners, that's at 1487 of the bundle, but we don't need to go there.
Certainly, but the decision taken by Mr. Ackerman is that he was now voluntarily withdrawing from his role in the task team as well as in the further management of TRC cases. I would then take over his responsibilities, and he then indicated that Mr. Marga would then continue to deal with TRC cases, reporting to me and not to Mr. Ackerman. We had another senior state advocate in our office, Ms. Bukau, and that she could also be made available to assist me. So now I was now back on TRC cases
Yes.
again.
And at paragraph 54, you say the cases you took over from Mr. Ackerman did not include the Timol matter. And do you know why that was so?
I subsequently learned that it had been closed after I had originally dealt with the matter in 2003.
Do you know the reason that it had been closed?
I think there was a mistake that a person thought the only inquiry was relating to Mr. Powell and not looking at the other investigations that had been requested. But this was done after my time, so I can't really comment.
Yes. Can you then take us to paragraph 55 and take us through that?
Yes. Now, immediately I said I now must participate in the task team meetings, but I discovered that they were not meeting, nor were any cases being subject to active investigations. I don't know if you want me to deal with Annexure AD. If it's
No, that's not necessary.
No, certainly.
Can we pick up then at paragraph 57?
Yes. What happened is I then started meeting with
I
Commissioner...
perhaps just want to ask you this. Dealing with AD 18, was that a voluntary handover by Mr. Ackerman to you?
Correct.
Paragraph 57 then?
Correct. Madam Chair, what happened is to get the task team up and running, I then had a series of meetings, firstly with Commissioner Jacobs. He was the representative from the police and the task team, and then Mr. Pete Richer from the NIA. Mr. Richer was a deputy director general in the NIA, but he had from time to time attended task force meetings, and I had a lot other dealings with Mr. Richer outside of the TRC matters, where he was always very willing to help us. So I started talking to them with the aim that we can get the task team up and running and we can start doing investigations again. And they indicated that the police and the NIA would become involved, but subject to approval from their principals and on the basis that it would again function as the task team had functioned. So all those discussions were held, and I was at that stage optimistic that we would get everything running again. So then I assisted Mr. Mche, who was then the Acting National Director of Public Prosecutions, to draft a memorandum to the Minister of Justice, informing him of what we had done and indicating that Advocate Mche indicated he would then further report to the Minister once the task team was meeting.
Yes. And to orientate the Commission, that's on the 17th of February 2009, and the memorandum is AD 20.
That's correct.
And it's to be found in the Commission's bundle at 1492, if I'm correct.
That's correct.
Can you very briefly go to AD 20 and perhaps just take us through the paragraphs that I've identified and any others that you want to go through? Chair 1492.
There we are. I found it. I'm just turning to page 1. Yes, certainly.
Yes.
AD 20 is in fact a copy of the memorandum.
Good.
It shows at the top the stamps that was received by the Director General Justice, the Deputy Minister and the Minister.
Yes. In paragraph 2, you give the background generally. In 2.3, you say the victims were dissatisfied with the lack of progress being made in their matters, and in certain cases appointed lawyers who declared the intention to institute legal proceedings against the NPA. Certain interventions from my office were necessary in urgent matters.
Yes, that's correct.
And then 3.3, no requests to investigate TRC matters have been received since November 2007, and it is anticipated that once the matters on hand have been dealt with, that the chapter on these cases may be closed. In its report released in 1998, the TRC did in fact recommend that a time limit should be imposed on such prosecutions. Do you offhand remember the time limit?
No, it was just a general statement in the TRC's 1998 report that they said that there should be a time limit to prosecutions.
Good. In 3.4, you then deal with the matters that are on hand at present, and there's a list of matters. We can skip that and go to paragraph 5, where you say, although the Pretoria High Court has declared the guidelines unconstitutional and an appeal has been noted, there's no reason why the investigations cannot proceed in the interim.
That's correct.
And in 6, given the unique circumstances surrounding the TRC cases, NIA has been requested to compile a threat analysis of the risks attached to such investigations. I'll forward the analysis to you upon receipt. And then there's a sign-off by several people. I think I can read some of the handwriting, but you might be able to do so better.
Let me try
Can you
and see
deal
if I-
with each of the comments by Advocate Similani for the DG Department of Justice and Constitutional
correct.
Development, and thereafter with Advocate Delanga, Deputy Minister of Justice and Constitutional Development, and then Mr. Invasurti, the Minister of Justice.
Sir.
Perhaps just take us through
Yes.
their comments on
The
memo.
Director General indicated as follows: it may be useful that the Minister first discuss these matters with the IMC. Now, IMC, Inter-ministerial Committee, so that the acting NDPP can be advised how to proceed, especially on what the mandate of the NPA is on these matters, if at all.
Yes. And then Advocate Delanga.
I find it more difficult, but I think I will be able to convey what he says. I cannot find fault with the approach adopted. In fact, in law, the NDPP must proceed with prosecutions or not if requested. To ensure this does not take place in isolation, the task team was established as part of prosecuting policy. As this is a sensitive matter, I agree, and I don't know if this is urgent consultations. I can't make out that. Consultations with the NC. Now, I take that that would be the National Commissioner of Police and the President.
My attorney says NSC, the National Security
Oh, I
Council.
see.
Okay. And the President. Is that correct?
And then lastly, the Minister said investigations must proceed, ! However, matter can be raised in the IMC meeting.
And what was that about?
I was never informed of whether that meeting took place, and if it did, what the deliberations were.
All right. So if one can just pause at this stage, are you aware of any political interference, or is the position rather that matters are being given attention and there's a desire to progress those matters?
What I will say is that clearly the NPA wanted these matters investigated. It's the NPA that did all the steps to try and convene the task team, and you can see in the memos written by the National Director that he was emphasising how very important that this be done.
Yes. In paragraph 58, you say the TRC committee, however...
No, finish what you're doing.
just to round off, paragraph 58, you say the TRC committee, however, never reconvened. Do you know why that was so?
I did not. We heard nothing further after that memorandum was sent back to us. See, attending high-level meetings would be dealt with by the acting national director, not me. Yes. And we certainly didn't get any further feedback out of any follow-up ministerial meeting.
Yes. The Commissioner has something to put to you.
Thank you. Could I take you to paragraph 2.2 of your memorandum?
Let me ask.
Page 1492.
1492.
Yes, I have it now.
And it's recorded there, since 2007, the task team has not sat due to the fact that matters relating to it were tabled before the Ginwala Commission. The effect thereof was that investigations into TRC matters could not continue. Are you able to speak to that? Was this before your time, or
Commissioner,
back?
I was not directly involved.
Right.
The persons who can best explain that would be Mr. Ackerman, who was the senior member of the PCLU, who was in the team. Dr. Ramapiti was the chairperson, and Mr. Pakoli was the national director. So they would have had direct knowledge on what happened there. As I said, I only attended 2 or 3 meetings on, at the request of Mr. Ackerman.
Okay. And just very generally, what was your understanding of the role and function of the task team?
I understood it as was written in black and white in the NPA TRC guidelines. The responsibility for the cases, managing the investigations and making decisions is the responsibility of the NPA. I saw the other people there as simply assisting the NPA in the execution of its duties. That's why we said we would like the intelligence agency so they can warn us of any risks or dangers that might take place in the investigation. We needed the police to have a dedicated component that can focus properly on these matters. It would be a disaster if these cases had to go to the detectives who are at the local police stations, and the cases would be scattered like confetti between low-ranking policemen. Justice was critical because we would have to get substantial evidence from their archives. It was not only the TRC records, which are national archives. There was a policy, if a person was detained by the security police, that person had to be inspected twice a week, no, once every 2 weeks, by a magistrate of the district where the person was detained. So the Department of Justice had what were called detention files. This is the person, this is all the information that is on the file while a magistrate was sitting. If he's released, then obviously the file's closed. Now, what we found is these justice files vary. Sometimes it's not more than short reports that tell you nothing and lots of news clippings. But on other occasions, they're very detailed information supplied by the security police, why the person's been detained, what information he's saying, who else is being implicated. So that's another source, and those are held directly in justice. They were never transferred to state archives, so that's why I saw their role. Obviously, the police were there to investigate, and we would want it to be done at a high level. The one person, I can say, look, here is a case. It doesn't matter where in the country it's committed. I give it to that person will then identify the right detectives to do the case, rather than me having to go all over the country asking local branch commanders to open the cases. NIA, what had happened is certain former security branch members had been incorporated into the agency post-94, like Dirk Coetzee and Willie Nokia. So these people would be able to, from the inside, know if you approach this person, he would be willing to cooperate. Perhaps we can talk to him ourselves. But just the general threat analysis, if there is a risk to the life of a witness or any other improper activity that could derail, the NIA would give that information to us. And that's what they did in the political violence cases that I worked on, and also the nuclear case I dealt with. And then, yes, the DSO were there. So they would then have to sit with the police and work out a shared responsibility about who will investigate what cases. Because there were some DSO members who previously been part of the special units that investigated TRC cases. So perhaps in those cases they'd be better placed than a police officer who has no experience in the matter.
Thank you.
Thank you. Can we then deal
Mr.
beg your
Bana,
pardon?
this memo by the acting National Director of Public Prosecutions, Mr. Mpie, to the Minister of Justice and Constitutional Development. Now, at page 1495, paragraph 5, there Mr. Mpie says, although the Pretoria High Court has declared the guidelines unconstitutional and an appeal has been noted, there is no reason why the investigations cannot proceed in the interim. Then there are views or decisions by Advocate Similani, by Advocate De Lange, and Mr. Suti himself. Now, those decisions or views are in handwriting. Advocate McAdam tried his best to read the handwriting. I think we need this to be typed out and provided to us.
We'll assist with that. Thank you, Commissioner.
Thank you.
My attorney's taken note of that and will assist. Can you then turn to paragraph 61, Advocate McAdam?
Certainly. Because the task team had still not reconvened, I was requested by Mr. Chair, the Acting National Director, to see what else I could do to get these matters investigated. So if you want me to then just...
Yes, very briefly.
What had happened is, when I was doing the political violence in KZN in the 1990s, I'd worked very closely with Mr. Raymond Lala. He was at that stage in the Police Crime Intelligence Division. Subsequently, when I came to Pretoria to be part of the DSO, he then became the divisional head of crime intelligence. So the whole crime intelligence throughout the country fell under his portfolio. And thereafter, at this time, service of the South African Police. So now he was in charge of every single detective in every single police station throughout the country. Because I had known him and we'd had a very good working relationship, I believed I could approach him directly and he would give me the necessary assistance. I may mention, as far as the DSO was concerned, that in 2007 a political decision was taken to disband them, and in 2009 the process was already in place to disband them. There were amendments made to the NPA Act removing them, and then amendments to the Police Act to create the Directorate Priority Crime Investigations, DPCI, a police unit which would take over the functions of the DSO, and the DSO ended in July 2009. So in my point, it would serve no purpose in trying to get the DSO again to agree, because they only had a very short lifespan. But I did. Do you want me to proceed with my engagements with Commissioner Lala?
Yes, please do so.
Certainly. I had a series of meetings with the Commissioner. All these meetings were very positive. He was very keen to help me. We didn't discuss individual cases or give him police dockets, but I was outlining the type of cases, the issues, the type of skills that would be required from investigators. And the upshot of all those discussions was shortly before the DSO was disbanded. He indicated that there are a number of former policemen who had previously investigated TRC cases, who had gone over to the DSO but were now coming back to the police. So he said to me, his plan is that they will form a project reporting directly to him, he would budget them, and they would work doing no other work than focusing on these cases, no other responsibilities. He would personally finance their operations out of his head office budget. So I said, well, that's fantastic. That solves my problems. The people that were coming over were people I'd previously worked with. I knew they were experienced police officers, would be able to very quickly get into these cases. Must I tell you what happened next after that meeting?
Very briefly.
What happened is I received a phone call from Commissioner Lala. Please, could I urgently meet with him? He said to me that the National Commissioner had directed that these cases must go to the DPCI, and therefore all his arrangements my arrangements with him fall by the board. Why those cases had to go to the DPCI was that the DPCI was not created as a brand new investigative agency. All that happened is the specialized units of the detectives, the organized crime, commercial crime, were just transferred over to DPCI. So it was just a change in name. And then clearly, Commissioner Lala would now be left only with the general detectives who are based at the police stations to do localized crime. So those people would not be able to do the specialized investigations I needed. So it's clear that I would have to talk to the DPCI and get them to investigate the matters.
Mr. Bana, I think we've got to take a tea adjournment at this juncture.
Thank you.
We'll take a tea adjournment and reconvene at 11:20.
Thank you, Chair. Thank you, Chair. Advocate McAdam, I'd like to now go to paragraphs 75 and 76 of your statement. You deal with what occurred on the 4th of February, 2016.
Correct. I may just add that the DPCI did agree to investigate, and they started investigating these matters again towards the end of 2010. But to deal with my counsel's issue, on the 4th of February 2016, Dr. Pretorius had been appointed as an acting special director and head PCLU. He informed me of a meeting that had taken place with Mr. Varney, Weber Wenzel Attorneys, and the Foundation for Human Rights, where a request was made to reopen the Ahmed Timol and Dr. Aggett matters. And then I was requested by Dr. Pretorius to furnish an opinion on the matter. I did so. I set out the work that had been done on these cases, and I advised that a decision to hold an inquest would only be taken once it had been established one could not bring murder charges.
Yes, your opinion is annexed as AD 24. We don't have to go there for now. And in paragraph 76, you say you continued to work on both the Timol and Aggett matters until you were instructed by Dr. Pretorius to lead a DPCI investigation into terrorist activities in the Johannesburg area. Dr. Pretorius assumed control not only of the Aggett and Timol matters, but also of the entire TRC portfolio. So for a time, you had nothing further to do with the
That is correct.
the Timol matters, which the Commission is interested in. If I can then ask you to go to paragraph 83.
Correct.
If I may ask Mr. Banner, Advocate McAdam, how long did it take you to continue working on both the Timol and the Aggett matters?
What had happened, Madam Chair, is that in, I think this was October 2015, I was supposed to be managing the foreign bribery portfolio, but another colleague had taken those dockets away, despite the fact that the national director had indicated I must continue with them. And then I decided, because I cannot work on the OECD in the absence of the dockets, let me see if I can help out on the TRC, because I knew there was a problem with these cases. So in the Aggett matter, I was the prosecutor who had directed that the matter be investigated by the DPCI as a result of representations from a group called the Friends of Neil Aggett. These were doctors who'd studied with him, and they were calling for an investigation. What happened is, so I had tasked out the police investigation, and I'd had a lot of help from our missing persons task team. They were identifying all the former detainees who could provide relevant information. And we did other work on it. The Magistrates Court record had been destroyed, but Advocate Bezos had donated a substantial copy of his record to WITS. So we arranged to have WITS break down their website into little blocks, because we couldn't print the stuff on our small office printer. And then we got approval to appoint a printing office to print 2 complete records of everything that also was giving us very useful information. What I was doing is I was going through the evidence of the police officers who testified, looking for improbabilities or contradictions, and also seeing whether there was one who might likely be prepared to be a witness. So that is what I did up to that point. On the Timol matter, I then found that this matter had been closed in my absence. And at the time, I came home, and as I put the TV on, Advocate Bezos was being interviewed, and he said that it was clear that the version given by the police that it was not true and that Mr. Timol had been murdered. So I then sent an email to the DPCI and said, please, open an inquiry. On the very same day, they registered an inquiry and appointed an investigating officer. Then, although the inquest had been destroyed, there was some of it on the WITS website, which I downloaded, And again, I tasked the Missing Persons Task Team to start now tracing all the persons who were in detention. And obviously, I identified the police officer who testified for the police investigating officer to follow up. So that is what I had done, and it's all set out in my opinion. But then I had to attend to a very urgent and very serious terrorism matter, but the head of the unit, Dr. Pretorius, said he would not only take over the Aggett and Timol matters, but the whole TRC portfolio.
Fine, and then we were about to deal with paragraph 83.
That is correct, Madam Chair. What happened is on the 1st of February 2019, Advocate Pretoria was appointed as the National Director, and she called me to her office in March and said she wanted me to take over as the head of the PCLU, and in April the Minister of Justice then appointed me as an acting special director. So I now became responsible for the whole PCLU portfolio, which included TRC cases.
Perfect. And you say you did that until September 2021?
That is correct.
When the decision was made to remove TRC cases from the PCLU.
That is correct.
And then can you take us through paragraphs 84 and 85 and 86?
Certainly, Madam Chair, because I had been effectively out for a long time on this terrorism case in Joburg and previously on the foreign bribery portfolio, I needed to take stock of how many cases the PCLU had and what the status of those matters were. And that audit process showed that we had a backlog across the board because there were only 3 or 4 advocates in the PCLU, all based in Pretoria, who were trying to deal these cases all over the country. And it's important to emphasize that this is not limited to CRC. We had these very serious state security matters where you had to move quickly to prevent harm from taking place. And we also had to investigate all the international crimes under the ICC Act by virtue of a constitutional court judgment in the South African Litigation Centre matter. So it was a huge portfolio, and just 3 people, because what happens is when you get appointed as the acting head, nobody's appointed to take over your deputy post, so you're doing 2 jobs at the same time. So that concluded that we're not going to come right. At that stage, it was only Dr. Pretorius, Ms. Bokau, myself, and only 1 admin officer. And then if I deal specifically with TRC cases, they were being investigated by a component of the DPCI called the Crimes Against the State Unit. Brigadier Kaba was the head of the unit. So I asked him to give me a list of how many cases they had. And that was 30 cases. So it was reassuring for me to see that there were a lot more cases than when in 2009 the memo went to the minister identifying certain cases we want to investigate. And what I picked up there is that certain of the cases which are still under investigation in 2019 were ones that I had referred to the DPCI already in 2010. So that showed that the police were themselves struggling to investigate these matters. Not every case that was referred to was still under investigation, but there were certain matters. And further inquiries, I saw that only 4 of these 30 matters were receiving the attention of a dedicated prosecutor, which was also a concern. Must I go on to paragraph 86?
Yes. In your view, what was the reason that only 4 of the 30 had?
It was sheer capacity. As I said, you had Dr. Pretorius, who is now acting as the head of the unit. Now, the minute you act as head of the unit, you are then part of the MPA's senior management. So you have to attend enormous lot of functions that have nothing to do with directing investigations, making decisions. It's strategic planning sessions, policy sessions, budgetary reviews. So now he's trying to do that and then manage all these cases. I'm sitting almost permanently in Joburg. It was one of the most protracted cases I had. Literally every day in court there'd be a legal challenge. If there was not a legal challenge, you were working with the Joburg police officers to get the case properly investigated. And then there was only Dr. Bukau, and she was trying to deal with all the work coming into the office. And it's just not doable. We just hopelessly under-resourced. And, this backlog is not due to dereliction of duty, people being lazy. It's simply that they've got far too much work. And if we say there were only 4 TRC cases, they were significant. The first one that Dr. Pretorius did, and he appeared personally in the matter, was the reopened Ahmed Timol matter, and that led then to a decision to prosecute on a charge of murder against Sergeant Rodriguez. Dr. Pretorius also had to assist the prosecutors who were going to conduct their prosecution with all the background information. Another case that was receiving the attention was a prosecution instituted on the murder of Nokatula Simelane. She had disappeared in 1983. Her body had never been recovered, but the prosecutors believed they could still prove a murder case in the absence of that evidence. That was proceeding. There were lots of legal challenges by the lawyers, so again there was assistance given to the prosecutor. That matter was being prosecuted by 2 prosecutors from Joburg because of lack of capacity within the PCLU at the time. And then the other 2 matters that Dr. Pretorius was working was the Timol and Aggett matter, to continue the investigations that I had identified, and also the death and detention of Dr. Haffiji, who died in detention in Durban. So, I mean, a lot of work had to go into those matters. And obviously, so much efforts are there, you can't then focus fully on the other matters.
Yes, your statement then deals with what occurred in 2019, and if we can then skip to COVID, March 2020, paragraph 96.
Certainly. Madam Chair, what I had proposed to address this capacity is that the cases should be dealt with by the DPP's officers where the crimes were committed, with the PCLU providing an oversight and support function. Now, this meant we could now, we not only increase the number of prosecutors available, but we can simultaneously deal matters in different jurisdictions at the same time. So that did immediately show progress doing that. What had happened as well, the police were still investigating everything from their little component in Pretoria. We had asked if they could involve the regional DPCI. At that stage, the decision, well, that request was refused, but then in January 2020, there was a meeting between the National Director, myself, and General Labia, who is now the head of the DPCI, where he said he will now get approval to appoint retired police officers to work on 3-year contracts. They will work exclusively on TRC matters, which then addresses substantially all our concerns, because now we have extra prosecutors and we have full-time investigators. Now, this was the impact of COVID, is that all the offices were shut down, so General Labia was only able to make those appointments in mid-2021. Because even at a contract, there are enormously complex procurement policies that have to be followed. You can't just say to a person, here you are, here's off you go. So that only happened then. But with the COVID, you have offices shutting down, where you need to go to the state archives, justice. Those offices were closed down completely. There were other repositories of information that closed. DPP's offices were closed, staff was required to work from home, and there were also major restrictions on travel. What I must say is, when COVID arrived, the DPCI said, business as usual, we are going to carry on as normal, resulting in massive infections, resulting in orders to say, stay at your office or at home unless there's something that is absolutely urgent you have to do. Because, you know, I worked very closely with DPCI people throughout the country, and I was appalled at just how many people were contracted with COVID. One of my investigators working a case actually died. A prosecutor who was working with me also died. So these were all the impacts that we had, and clearly this all slows down the pace at which you can investigate. And we wanted to reopen the Aggett and the Khampepe inquest. But with covert, you couldn't have a hearing like this. Do you want to deal with how we try to overcome these matters?
I think for present purposes, just to say that you remained at the office 7 days a week.
That's correct.
Even met in parking lots.
Yes, that's correct.
due to the
Madam
COVID
Chair,
restrictions.
I was there 7 days a week because the covert led to an enormous spike in terrorism cases because everybody was now enforcing lockdown. Nobody was looking at people plotting and planning. And we had a very serious right-wing terrorist case where the plan was to carry out an attack at midnight on Black Friday. They had armed themselves with two semi-automatic weapons that had been converted to fire in full automatic, 6,000 rounds of ammunition, 12 pipe bombs manufactured, one of which had been tested to see they'd work. And they'd already identified their targets, informal settlements south of Johannesburg, and they were arrested, leaving that plot in a vehicle with all that weaponry. And what happened in that matter is we had to run the case out of the DPP's office in Mpumalanga, which had just been set up. We had a chief prosecutor acting as a DPP, prosecutors drawn from the Joburg and Pretoria offices and spending a lot of time doing. So I had to personally run that case myself, doing all the court appearances and assisted by Ms. Bukau on the legal research and preparing legal documents. But what we said is our office, I was at there 7 days a week, but then the office would close because the infections were so high they wouldn't allow anybody in. Now, Mr. Mzinyati, who at that stage was the Deputy National, to whom I reported, we used to meet in the parking lot so we could still try and keep the work going.
Yes. And you also say in, at paragraph 97 that you took advantage of the initial lockdowns to identify all deaths in detention and matters reported. Can you elaborate on that?
Yes, Madam Chair. With the TRC, we inherited essentially the work of the Goldstone Commission, and then there was a special police unit that fell under Dr. Yanda Oliveira. He was first the Attorney General in Pretoria, and that was known as the Da Oliveira unit. That's the unit that did the prosecutions of Wouter Besson, Eugene de Kock, Ferdy Barnard, etc. But the focus on those were on the premeditated killings. Nobody was really looking at the death and detention matters. Because obviously people wanted to have impact. These premeditated would properly be investigated, show that they were planned and, at a very high level. And that's why the focus was there. But now I'd looked at the Aggett and the Timol matters, and although I couldn't conclude investigating those matters, on what I saw was showing there's something wrong. These police versions that were presented in the 70s are not right. So I said, everything's shut down. I'm at the office. Let me go through the lists of death and detention cases. Because it was not only a list by the TRC, there were NGOs that monitored. So I looked at these lists, reconciled them, and we already did have some death and detention matters. It wasn't just Aggett, Timol, and Khampepe. We also had the Salaji matter. There were two people in Silverton who allegedly slipped in the shower. So I took the cases we'd already off. That left me with approximately 59 cases. Now, what I said is, once things normalize, we can distribute those cases amongst all the regions, because we did an audit. My audit also showed in which province the crimes were committed. And if we had extra capacity from the DPCI, I believed it was feasible to actually investigate those matters. What I may also add is, although the focus was on premeditated detentions, by 2019, a lot of the people you wanted to prosecute were already dead, as were their witnesses. So I believe that it was essential that we do these 59 death and detention cases. And must I proceed to... but my difficulty is I've come up with this idea, but now what about the poor police? If they are struggling with their 30 cases, how are they going to cope with 59 new cases where you have to start from scratch? There's no police docket, so was there an inquest? Was there a hearing at the TRC? What is the availability of witnesses?
Yes.
So,
You say there was a promise of extra investigators and that gave you some confidence, but did that ever materialize?
Due to COVID, the extra investigators were only appointed in mid-2021. And that's not any fault of General Labia, that to get those contract appointments, he's got to get a dispensation from the Department of Public Service Administration. It's no easy process. Thereafter, you have to follow a appointment process because there are, interviews, committees, and all those requirements. So he could only sort everything out 2021. So what we did is, in April 2020, Advocate Rodney de Kock from Cape Town replaced Advocate Mzinyati as the head of MPS. There's a report which I gave to Advocate de Kock in May, a month after he'd assumed duty, giving him a breakdown of all the work that I was doing on the TRC cases and flagging these additional 59 cases. And then I drafted a letter for Advocate de Kock to submit to General Labia, identifying these extra 59 cases and alerting him to the need for additional investigative capacity. We also had a Microsoft Teams meeting with the General and his staff to discuss this issue. The bottom line is I then started having a record of the cases. This would list, column 1 would be cases already inferred, they are being dealt with by a police and a prosecutor. Cases that will be referred once we have capacity. So this is where these death and detention cases were in the awaiting additional capacity. A third category, on some matters we had so little information we didn't know where to refer them. So that was listed separately, and then we try and get the extra information and get it to the right prosecutor. And then we also had a couple of crimes that took place outside South Africa that we had listed as foreign offences.
If you can then pick up at paragraph 104,
yes.
And you're at 30 November 2020.
Yes, certainly. If we look at AD 29, that is the spreadsheet which I compiled. It shows that we had actually now in total 112 cases, and it's split into active and awaiting capacity. I don't know if it's necessary to take the Commission through it, but you can see already we have an improvement from 30 cases to 112 in a year, and also with the COVID virus wreaking its havoc.
Yes. And you conclude on this aspect at paragraph 110, where you say, in my view, progress was made under difficult conditions by prosecutors and investigators working on the cases, despite their other responsibilities, and you personally didn't take a single day's leave in 2021.
That is correct, Madam Chair. Firstly, I was retiring in October. I wanted to leave with a clean slate, not things hanging in the air. But it was a nightmare year for me. We not only had this right-wing terrorism case that I had to deal with, we had the leader of a foreign terrorist organisation that was bringing applications in the Joburg and Pretoria High Courts. I had argued this matter in the Constitutional Court a couple of years ago, so I was best placed to deal with those matters. And we had the July unrest land on our laps because our portfolio did cover the July unrest. What happened there is every day I had to have a meeting with General Labia and his commanders to try, and everything was out of control. It was absolute chaos. And we were now trying to say, what cases can we identify that we can get the right people stop this? Also, most of the crimes related to posts on social media, incitement to violence and murder, etc. So I had to advise individual prosecutors and investigators on what were cases that we could properly pursue, because there was fake news. You had other stuff that they were using platforms that do not cooperate with law enforcement, like Telegram, Signal, etc. So I was trying to deal with that and at the same time be able to retire. My Joburg terrorism case only finished 1 week before retirement.
Yes. That then deals with generally what was happening with TRC cases. There's a section then in your statement that deals specifically with the allegations by Mr. Kaji
Yes, certainly
against
from
you.
115.
Yes. Can you take us then carefully through those paragraphs 115 to 123?
These are in response to allegations made in an affidavit filed at this commission. Mr. Kaji alleged that he had never mentioned Ivor Powell at all. It was a Mr. Piers Piggo, and he'd actually given me Mr. Piers Piggo's TRC file. Now, that is not correct. Piers Piggo and I had worked very closely together when we were both in the TRC. I would never have made a mistake between him and Ivor Powell. Secondly, I was never given a TRC file by compiled by Mr. Piggo. I referred to my letter in May 2003 addressed to Mr. Leese, where I identified what had been provided to me. And I may mention that 2 days after Mr. Kaji met with me, already instruction was given to the Chief Investigating Officer, and I emphasise Chief Investigating Officer, not a low-ranking police officer. Mr. Leese I knew as a very experienced police officer. He had worked on certain TRC cases arising from the Joburg area. I may also mention that in October 2015, I did immediately instruct the police to open an investigation into the Timol matter, and this was before the request was brought by the Foundation for Human Rights to have the matter looked at. So when they approached Dr. Pretorius, the police were already investigating.
Yes, and you had done that mero motu without any
That's correct.
insistence or pressure from anyone.
No.
At paragraph 116, you deal with the allegation of reluctance on your part to deal with the Timol matters, and can you take the Commission through that?
Madam Chair, I stand by what I said. When Mr. Kaji met with me, an instruction was given to gather information to lay the basis for a Section 28, and in October 2015, when I learned that the matter had been closed, I got the police to reopen the investigation.
Yes. And you say in that paragraph that you believe your energy and efforts to advance TRC related matters, despite the challenges which have been mentioned, speak for themselves, and you had no wish or motive not to advance the Timor matters.
Correct. When there was an application for stay of prosecution, I was approached by the head of the unit, and I immediately offered my assistance and provided a supporting affidavit, which was used to oppose the stay of prosecution.
Stay of prosecution in relation
to the Timor matter, where
matter,
prosecution
yes.
was instituted.
In paragraph 118, you say you appreciate Mr. Kaji's frustrations and pain over his uncle's case not being investigated in a timely manner. I deny any dereliction of duty on my part, and further deny any need or attempt to conceal the alleged dereliction of duty. I also reject his further allegations that I, as a prosecutor, prior to April 1994, protected my former colleagues from prosecution. I have demonstrated all my efforts and the extent to which I went to have the matters prosecuted. Do you wish to add anything to that?
No, Madam Chair.
And then you deal with, in 119 of the statement, you draw the Commission's attention to an email received from Mr. Kaji on 16 April 2022. Can you take us through that?
Yes, that is correct. This is also in response to allegations levelled against me in his affidavit. I confirm that after I had retired, he wrote to me and said he'd been through my affidavit, which I'd filed in the Rodriguez matter, and he realised that I had discovered important information that he lacked, and could I supply it? And I immediately then referred him to the former investigating officer and to the head of the missing persons task team, who had assisted me in gathering the information in 2015.
Is that AD 33? We
That's
don't have to
correct,
go
yes.
there, but AD 33. In paragraph 120, can you take the Commission through that carefully?
Yes, this is also a matter of concern to me. As I said, I did file a confirmatory matter in the Rodriguez case. I did not mention the words political interference at all in the matter. I merely set out facts and documents that I had first-hand knowledge and documentation which the NDPP's office manager had given to me, which belonged to Mr. Pakoli. And in respect to those documents, Mr. Pakoli gave me a confirmatory affidavit confirming the authenticity of those documents. Now, when the court delivered judgment, it said that that affidavit of mine provided further evidence of the extent to which the NPA had been subjected to political interference. Now, Mr. Kaji then said, no, that affidavit is false, and that is false insofar as my claim of political interference is concerned. The true position is I was trying to hide the fact that I'd done nothing at all. And that is not true. The finding of political influence was drawn by the court looking at all the affidavits in the case, not mine, and merely, obviously, my affidavit gets pieces of the jigsaw puzzle, and that leads to that conclusion. So I deny that I ever tried to use political interference as an excuse for not doing my work.
Yes. In 121, you also deny that you failed to earnestly follow up on the leads that Mr. Kaji furnished.
That's correct. I refer to my letter of May 2003 to CIO Leask.
You also deny that you unlawfully placed the burden of investigating his uncle's death on him.
That's correct. All I asked him was to provide me with documents that he had in his own possession. So he could have faxed or emailed them to me, or I could have gone and collected from him, and that's all I did.
Yes. And you say in 122 the logistical and resource-based constraints that we operated under has been set out in detail in earlier parts of your statement. At no stage did you place any onus on Mr. Kaji, whilst I probably invited him to supply any additional information to assist with the case. This in no way shifted the ultimate investigative responsibility onto him.
That's correct, Madam Chair.
That deals with the allegations that Mr. Kaji has made. Is there anything else you wish to say in that regard?
Not at all, Madam Chair. My affidavit is purely in response to the Rule 3.3 notice served on this.
I then want to deal with an aspect that's not in your statement. It arises from a document, I think, that we got from the evidence leaders. I speak subject to, from you. After the statement was prepared, and can I beg leave to hand those up, Chair?
Yes, you may.
It's a memorandum dated 16 August 2007, and it proceeds with the next numbering in the bundle, so it starts at 1597. We'll make copies available to our colleagues as well. Oh, no, those are unnumbered. Can you take them back as the commission numbered?
Sit back.
Have you got a copy in front of you?
I do.
Okay.
Sorry, Chair, we're also waiting for copies. Do we have any more copies, perchance?
No, I think we're a bit short. That's the last. My attorney has one and I've got one. This is a memorandum from you to Advocate Pikoli. It's dated the 16th of August 2007. Before we go into certain paragraphs, can you tell the commissioners the purpose of the memorandum?
Correct. Madam Chair, it is respond to a fax that was received from AfriForum addressed to Mr. Pakoli, the National Director. I have not been able to locate this fax, and I'm now not sure if it was a fax or a letter, but it was a call to either now prosecute the leadership of the ANC or to stop all prosecutions into TRC matters. Now, this fax, let me just see if I have a date. The date of my memo is 16 August 2007. The day before, Mr. Ackerman entered into a plea and sentence agreement with the former Minister of Police, the former Commissioner of Police, 3 other members of the police, where they pleaded guilty to a charge of the attempted murder of Reverend Frank Chikani. They had put poison on his clothing with the intention of killing him. And Reverend Frank Chikani was, I'm sure, the head of a church council, and he was also a member of the United Democratic Front.
Yes. And you referred to the AfriForum fax as you then described it in paragraph 2, but I'd like you to go to paragraph 5 at page 1598.
Paragraph 5. Yes, Madam
Perhaps
Chair.
just in paragraph 4, you record, as in the case of all previous complaints, AfriForum refuses to produce the evidence upon which it makes allegations.
That is correct. Their letter said specifically that although they had evidence proving the case against the ANC, it was not going to be made available at the time when it was when they wrote to Mr. Pakoli.
Yes. And then please take us through paragraphs 5 and 6.
Yes. Certainly, just as a very brief background to paragraph 5, is that the South African police had pre-94 investigated some 400 dockets against the military wing of the African National Congress. Those were the dockets that were held by Advocate Fick in the DPP's office, Pretoria, but they then came to the PCLU, and Advocate Ackerman indicated he would then start reading those dockets and making decisions on them. So he did that, and I believe that he read about 50 or 60 dockets. And this was all done in June to August 2003. The next step in the saga is that in early 2004, I cannot recall the date, but Mr. Ackerman, myself, and Dr. Pretorius were called to the National Director's office. He then inserted a videotape into his TV, and he played back a recording of a meeting that the 3 of us had had with Commissioner Lala in August 2003. I was asking Commissioner Lala to assist me with 2 of my cases where we believed the intelligence community would be best able to advise us. But as the meeting adjourned, Mr. Ackerman said he has to make a decision against the President of South Africa, who was at the stage Mr. Mbeki. And Mr. Ngcuka said that this tape recording, we were unaware that a recording was made of that meeting. But Mr. Ngcuka said that this tape recording was presented by Commissioner Salebe at a very high-level government, and the allegation is that PCLU is on the point of arresting the President and a number of very senior government officials who previously been part of the armed struggle. And the final allegation is these 400 dockets in the DPP's office, Pretoria, were being used for the prosecution against the President and these other persons. So Mr. Ngcuka then said to me, take over from Ackerman, read those dockets, and I want a decision on whether there is a case or not. What I also need to refer to is that the TRC, and I think in 2 separate judgments, I have one but not the other, had refused amnesty to the ANC leadership on the basis that they took collective responsibility for all actions committed by their supporters when their supporters believed that this was advancing the cause. And the TRC said, no, amnesty is for where you admit to a specific crime, you have to persuade us it's political, you made a fool. So it was refused on that basis, not on the case that they admitted committing crimes and hadn't made full disclosures or that they were not political crimes. And I was told I had to make a decision quickly on the matter. I could not obviously read all 400 dockets, but the police who were in charge of those dockets had compiled a register which would show the police docket reference, the charge, the suspects, and the outcome of the case. And the outcome fell into three categories. Firstly, convicted and sentenced. Category 2, amnesty granted. Category 3, undetected. So what I decided to do is do spot checks on that register. If the register said there was a conviction on, say, case 35, I draw case 35, I read it. Yes, it's accurate. If case 54 says amnesty is granted, I draw that case. Yes, that's correct. Undetected cases were also undetected. And I said on those matters, there was nowhere to leads as to where to go to look for the perpetrators. And I said, well, if these have been investigated fully in the 1970s, 1980s, with all the resources of the regime, and they couldn't solve those cases because they had resources that we don't have. They could detain people indefinitely, denied access to lawyers, get them to make confessions. They weren't required like me. I would have to have evidence under oath, arrest a person, must appear in court within 48 hours. I must have the trial start within a reasonable time. So I said that I'm not going to get anywhere on those undetected cases unless somebody comes forward and says, I want to come clean now, I was involved, then obviously it's a different thing. So I went through, I was satisfied the register was correct. The interesting thing about that register, there was no case registered against President Mbeki.
Yes. You say in 5, you also held discussions with the 2 SAPS members who were in charge of such dockets?
Yes. You know, why I asked them that is they had them under their control, so they drew my attention to the register. They also gave me background information. An important document that I looked at was that it wasn't part of the 400 dockets, but it was a leverage file which contained reporting by the various security branches to their head office. Now, that would fall into 2 categories. Either they were deeply placed undercover agents who'd infiltrated the ANC, or they had informers working for them. And what I picked up is, as far as the command structure of MK, their reports were mainly on the basis of very sensitively placed sources. And they say there's a meeting, it lists about 18 members. And the one that I remember was that there would now be an attack on polling stations at the 1988. So it led me to conclude they were working mainly on informer information, and they also had former members of Nkonto Sizwe that, when arrested, elected to join the security branch. There was this term, I don't know if it's derogatory, I don't want to use it if it is, they were referred to as Askaris. So it looks like the cases were resting on informer information and to get into a high-level MK meeting with 18 people, because if I looked at the name, Chris Hani was there, Joe Medise, Sipiwe Nyanda, etc., that would probably be somebody who was in that meeting. And I said it's highly unlikely in 2004 that this source will come forward and admit that he was a spy for the security branch, whereas he may well be sitting in a key position in government or cabinet. So these all led me to So that was my assessment of the 400 dockets and that file that they had.
Yes.
But I said I'm not stopping there. With the assistance of Ms. Fullard, who was a former...
Just before that, you say in paragraph 5, I could find no evidence implicating the President or any other senior ANC member. In all the dockets, the implicated persons had received amnesty and no further prosecution of them was therefore legally justified.
Yes, that's correct. But now what I did is these were the people that actually were responsible for physically carrying out those crimes. But now, when you look at the blanket amnesty case of the TRC, there were some prominent senior commanders in MK. They would never be on the ground, but they would give instructions from Lusaka or elsewhere. So then, with the assistance of Ms. Fullard, we then checked all the TRC amnesty applications regarding people who were very high up in Mkhonto with Caesarea. And that again confirmed amnesty granted to the people.
Yes.
And particularly, General Sipiwe Nyanda was getting amnesty in several matters, and he was the person that most of these activities came out of his component.
All right. And then in paragraph 7, you deal with the position in the 70s and the 80s and the different position that prevailed
That's correct,
thereafter.
Madam Chair. When these cases were prosecuted in the 70s, 80s, there were these terrorism laws, the Internal Security Act, which contained presumptions and a lot of evidence that would not be found constitutional once we moved to democracy and had a constitution. And then importantly, so I believed I could not come in 2004 and prosecute under legislation that in all likelihood would be declared unconstitutional. Because when we talk at presumptions, these ran across the board. If you had more than so much marijuana, you were presumed to be dealing. If a firearm was found in your house, you were presumed to be the owner of it. And one by one, the courts declared all of those presumptions unconstitutional. And how I said I'm bound by the common law of the land, which is I must fall back on the doctrine of common purpose. And that had been interpreted in an SCA judgment, the State versus Safotsa, that is the Uppington 26 case, which was a TRC matter. And there the SCA had said, common purpose requires you either participate physically in the crime or you are at a meeting where you agree that the crime should be committed. So that was the test that I applied when I did my evaluation of all the evidence. And I did provide a report to Mr. Ngluka saying that I cannot, on what I have available to me, decline to prosecute, which was accepted by Mr. Ngluka.
Yes. And is that what you deal with in paragraph 8? You say, in the light of the above, I was of the view there was no admissible evidence upon which to investigate or prosecute the ANC leadership, and I submitted a memorandum to Mr. Ngluka to this effect. Subsequently, the NPA released a media statement to the effect that no grounds existed to investigate.
That is correct, yes.
Did you arrive at that conclusion as a result of any interference or influence by anyone, or was that your personal decision
Madam
based
Chair.
on your
It was
assessment?
based on the evidence that was available at the time and applying the doctrine of common purpose.
Thank you, Chair. We have nothing further to lead, Mr.
Is that,
McAdam on.
is that your evidence in chief?
That is the evidence.
Thank you. Mr. Nell, any clarificatory question?
Indeed, I think I should have another mic as well. I have clarification questions, but I don't have the correct microphone.
You will be assisted in that regard.
I think I will have to move. Apologies. I hope it works now. Yeah. So just wanted to clarification questions on the portion of the evidence that was not included in the affidavit.
Yes.
That was just made available now. So as far as clarification is concerned, Mr. McAdam, if I understand correctly, your decision that there was no evidence against any senior ANC officials and the President was solely based on the evidence that was collated by the police and contained in the dockets that you had a look at.
As well as the amnesty application, which was refused by the TRC.
Yeah. Okay, so was there a correlation between the amnesty that was allowed for Mr. Nyanda and the specific cases that you had?
Yes, what had happened is in several of these police dockets, Mr. Nyanda was reflected as having received amnesty for those.
And is it your evidence that there was no docket amongst the 400 dockets where amnesty was not given to Mr. Nyanda?
Madam Chair, I cannot recall at that stage. I remember that his name came up frequently in the dockets and frequently in the amnesties that were granted by the TRC, where he, in his individual capacity, assumed responsibility for activities that he had authorized.
As an experienced prosecutor and investigator, you saw no reason to direct the police or investigators to investigate anything further, but you just relied on dockets. There was no instruction to look further into any of the dockets.
Madam Chair, what happened is, after I had made my report to Mr. Nuka, he gave a direction that the dockets must be removed from the DPP's office, Pretoria, and taken back into police custody. I was present when he gave that instruction to Deputy Commissioner Price and Deputy Commissioner Williams, and Mr. Nuka made it clear, although the dockets are going back, this does not mean that investigations should not proceed, and should the police then have cases where there are specific charges identified, then they must submit those dockets.
But the question had more to do with yourself, Mr. McAdam. Did you give any further instructions on possible investigations in the case dockets or not?
Not at all.
Apologies, I don't know why that happened, but it happened. I don't know if you followed the evidence that was led by Mr. van der Merwe earlier in the proceedings.
Mr. Nel, just sorry, the reference to you don't know what happened, but it happened is with reference to the microphone, not to what Mr. McAdam say.
Indeed, yeah, indeed.
Yes.
Mr.
I don't know what
Nel,
happened.
Mr. Nel, I know you want to put a version of Mr. van der Merwe, but is it fair in relation to this witness when he wasn't here when Mr. van der Merwe was giving evidence?
Madam Chair, that's why I asked the question. I just asked him
Yes.
if he is aware of it. If he tells me no, then I know how to act. So the question was merely, are you aware of the evidence that was led by Mr. van der Merwe in this proceeding?
No, I'm not, but what I can confirm is when I took over the TRC cases...
No, just respond to the question.
Yes, no, I'm not aware of his evidence.
And so my last question as clarification is that you said there were 3 types of cases. The cases amongst the 400 or the police case dockets that you received, there were those that people were convicted on.
That's correct.
There were those that was undetected.
That's correct.
And then there were those that received amnesty.
That's correct, yes.
So those 3 categories of dockets you perused and drafted a report.
That's right.
And there was no action or instructions given on those dockets where nobody received amnesty and nobody was convicted.
Madam Chair, those were still under the control of the police, and they were still required to investigate if evidence emerged on the matter. The two policemen in charge of these dockets were former security branch members, so they would be ideally placed to know where to go to get any extra evidence.
I'm glad you mentioned that. So those two policemen, can you recall their names?
The one is Colonel Henny Brits, and then there was a brigadier who was in charge of him. I can't recall the brigadier's surname.
I think it's, we all know that was Brigadier Nell.
I don't know. I just can't recall it. I don't want to blame the wrong Nell.
First name?
I don't have his first name. I might get it, but I don't have it now. But it was Brits and Nell. They were the two investigators with Advocate Bill Fick. That's also interesting questions. Just for clarification, the dockets that was handed over to you or to your unit, what was the purpose of those 400 dockets? Why was it handed over to you?
Because Mr. Ngcuka decided that all the TRC matters must be dealt with by one unit, and there may well be links between the two categories. You see, at the DSO, I'd worked mainly on the cases against the security forces and political structures. You know, various political parties were involved in violence during the TRC period. And, you know, it didn't really make sense that we're dealing with one and now Mr. Fick's dealing with the other matters. He was only the DPP of Pretoria, that those 400 dockets covered the whole country. He could not make decisions on cases outside of the jurisdiction of the DPP Pretoria, whereas the PCLU, we had national jurisdiction limited to the cases that fell within our proclamation. So if it fell in the proclamation, I could investigate anywhere in South Africa, but I couldn't obviously investigate cases that didn't fall under mine. That's the difference.
That's an interesting choice of words, that he could make decisions on those dockets, but you could make decisions. Were those then decision dockets?
They were clearly dockets that were opened and that the police were writing off the final outcome. So there were matters that were opened and prepared to be read and signed off by a prosecutor. I may mention, I don't know how long Mr. Fick had them in his possession, but I can confirm he hadn't identified any cases for prosecution before Mr. Ackerman took over.
So I hear what you're saying. So can I then accept that those were decision dockets? Because they were handed over from the police to a prosecutor to go through them and make a decision on them. So those were decision dockets, am I correct?
Yes, that's correct.
Now, did you decide them before you handed them back to the police?
I made a decision on the president and the other prominent persons. Mr. Ngcuka made it clear that the cases must go back to the police, they must continue with investigating those matters, and if there were cases where they needed a decision to be made, they were to submit those dockets back to us and we would deal with them as we would deal with any other TRC matter.
So can the Commission then accept that on instruction of Mr. Ngcuka, dockets were handed back to the police without decisions by a prosecutor made on them?
The decisions were made on the case that I dealt with. In the other matters, they were simply returned to the police to continue with the investigation. So if the police discovered evidence, they needed a decision, the docket would come back. I mean, we would not keep a docket in our office which required investigation because we're not investigators.
So this is not cross-examination, but it's clarification.
Mr. Nell, I think you are bordering on cross-examination.
I am. That's
and
why
you have a right to cross-examine upon a proper application presented before this commission.
Indeed, I understand
So
that.
I must warn you, you are treading on dangerous grounds.
as the Commission pleases.
Yes.
I warned myself, that's why I'm taking one step back.
Well, I'm warning you.
I accept the warning, gracious. May I then say, I just want to clarify, those were decision dockets, and you admitted those were decision dockets.
Yes.
You handed back, or whoever handed back those dockets to the police without the decision on every docket that was handed back.
My decision was limited only to the allegations specifically made by Commissioner Selebe, in respect of which the National Director required. It did not cover all 400. That's why we said those dockets go back, the police can investigate and resubmit.
So that's my last question. I know what you're saying about yourself, but can we just look at it more broadly? Mr. Nguka gave an instruction for the return of dockets, decision dockets, to the police without a prosecutor having taken a decision on those dockets. Is that correct?
Well, those dockets were with Mr. Fick. He was entitled to deal with those matters as he saw fit. So what I got was as dealt with by Mr. Fick, and there were no cases that Mr. Fick had identified for prosecution. As I said, I didn't look at all 400, but I didn't see, and I stand under correction because this is memory going back a long time ago, whether Mr. Fick had given directions on those matters. Because those dockets had already been investigated pre-1994. And Mr. Fick, I got to know him in 1983 when he was already a senior member of the NPA office in Pretoria.
That was your last question you indicated, Mr. Nell.
Chair, may I have the indulgence to... the document was handed over to me now. I did not receive one because there weren't enough copies. I never thought that I would be interested in this particular document. It wasn't disclosed to anyone. I asked for 2 minutes. There's one specific paragraph that I read that I just want to deal with.
On a point of clarification.
On a point of clarification. May I just have a quick conversation with Advocate Foster? I have an unnumbered document. May I refer, because I will ask one question of clarification. So the document I have is marked 1597.
Is it part of my bundle?
No, it's the document that you handed.
Is this one here?
Yeah, indeed. So if you page through the document to the internal memorandum to Mr. Pikole, from yourself, you send it to Mr. Pikole, Kalyani Pillay, and Mr. Ramaite, dated 16 August.
That's correct.
At paragraph 10, could you just read that paragraph into the record? Oh,
It is highly likely that your reply will be released to the media by Mr. Creel. I therefore deem it inappropriate to request him to make his investigation available, as this might create the impression there is a fact against the ANC leadership, and we'll have to have a repeat of the problems where the senior governments believed and we were planning to arrest the president.
So you never asked AfriForum or anybody for the, well, let's say AfriForum. You never asked AfriForum if they do have information about it, because there was instruction by Mr. Pikole.
That's correct.
That's as far as clarification questions concerned.
Thank you, Mr. Nell. Ms. Moroka.
Mr. McAdam, you talked about the fact that the TRC cases were taken away from you. I'm not very sure when that was, but it's pre-2007, is that correct?
Madam Chair, the only time the TRC well, what had happened is, Madam Chair, I was dealing with the matters until February 2004, when I had to attend to this urgent nuclear weapons case and other responsibilities. Then Mr. Ackerman continued with the cases, as assisted by Mr. Marga. Then in 2014, Mr. Nkasana, who's then the National Director, took me out of my other duties to deal with the OECD foreign bribery matter. And then thereafter, Dr. Pretorius dealt with these matters when he was appointed as the acting head from October 2015. And thereafter, when I was appointed as the head, I took the matters over from him in April 2019, and they were only physically taken away from the PCLU in September 2021, a month before I retired. They were then transferred directly to Advocate de Kock's office, the Deputy National.
And throughout all those occasions, Mr. McAdam, there was no sense or an understanding from you that there was political interference involved, and that is why you've been taken away from these cases.
Madam Chair, every time I was taken off those cases to do other work, it was turned to very, very serious matters, and not just to get me out of the way so that I can no longer contribute to TRC. I was required to lead the investigation into the corruption in the Northern Cape province, which led to a successful prosecution by a colleague of mine who took over the matter. I had to do with the foreign bribery, where South Africa was found to be non-compliant with its obligations in terms of an international treaty, and the OECD said if South Africa does not put its house in order, then there will be severe repercussions, and South Africa was given a mere 6 months to rectify. That's why I was taken out, and I had to work very hard to turn things around. When Dr. Pretorius took over, there were very, very serious terrorism matters that I had to attend to. The first one was Islamic State had radicalized people in South Africa, and they had been tasked to carry out attacks on junior schools, businessmen, etc. And then there was the right-wing case where they were on the point of actually carrying out a lethal attack. So at no stage was I taken off these matters just as an excuse to prevent any work being done on TRC cases. Every time I was taken away, another member of the PCLU would work on those matters.
And with the task team that was formed after the guidelines were approved, even then, you are not of the view that this task team was formed because it was a continuum of political interference?
As stipulated in the guidelines, the task team was created so as to enable the PCLU to be assisted by other departments whose contribution was absolutely vital. Without the assistance of the police to investigate, justice to give us access to files, we would actually be no better off than we were already in 2003.
Thank you, Mr.
Thank you, Ms. Morota. Mr. Vani.
Chairperson, we actually have an indulgence to ask the Commission. We've been tied up since Friday evening until last night with the review. In fact, the review only ended around 6 p.m. We haven't been able to get to grips with Mr. McAdam's statement and his many annexes. We have spoken to the evidence leaders, and our proposal is that we ask our follow-up questions tomorrow afternoon, as Mr. McAdam is also scheduled for tomorrow afternoon. We proposed to the evidence leaders, and I think they agreed that they would proceed with their questions, and if anything fresh emerged from our follow-up, then they could also canvass those.
Yes. Do you have any intention to apply for cross-examination of Mr. McAdams?
At this stage, we don't think so, because we don't have any fundamental disagreements with what he's saying, but we do think that he can assist this commission to get to the bottom of its terms of reference.
Okay.
May we just indicate tomorrow afternoon was a spillover date. There's considerable inconvenience to Mr. McAdam to come back. The statement, which is basically what we've dealt with, has been delivered since the 3rd. So between then and last Friday, there have been 10 days. Can we ask if Mr. Varney can just consider his position at the lunch adjournment, and if possible,
Yes.
if we can finish with the witness today so he doesn't have to come back tomorrow, just for Mr. Varney's clarificatory questions.
Yes, Mr. Varney.
Well, it simply isn't possible, because there's no ways that we can get to grips with his statement and annexes between now and this afternoon. And so we persist with our request, Chairperson.
Mr. Varney, are you able to go through your Mr. Advocate McAdam's affidavit this afternoon? From the look of things, depending on how long Ms. Rikhotso, do you have any clarificatory question to ask Mr. Advocate McAdam?
Thank you, Chair. Thank you, Chair. I don't have any clarification questions. I think he's placed everything that I needed quite well.
Depending how long the evidence leaders are going to be with Advocate McAdam's clarificatory questions, it looks like we'll have the better part of the day for which for you to go through his statement, to be able to put clarificatory questions this afternoon. Is it not possible to do that, Mr. Varney?
Chairperson, it would be exceedingly difficult to listen to the evidence in response to the questions put by the evidence leaders and go through the statement and annexes and prepare. There is a further matter which I have brought to the attention of the evidence leaders, and I suppose I should bring it to your attention as well. I have to spend at least lunchtime completing papers that have to be filed in the Supreme Court of Appeal in the COSAS 4 matter. Those have to be signed this afternoon in order to be couriered to Bloemfontein and filed tomorrow morning, which is the deadline. That's the matter in which crimes against humanity, apartheid as crimes against humanity, is before the Supreme Court of Appeal. And I have to spend lunchtime finalizing those papers so that they can be signed this afternoon.
So you are fully committed for the afternoon?
The evidence is going to be led this afternoon. Evidence is going to be led this afternoon, then of course I will be back. But otherwise, every other available moment, I have to finalize those papers, which we do have a deadline we can't avoid. And of course, just given our program before this commission and the review, normally, of course, if we didn't have the review, there would be no issue. We would simply proceed. But the review cropped up and we had to deal with it.
Yes. Mr. Siminya?
Chair, before we say anything in response, I must indicate that I'm informed that on the virtual platform, there is Ms. Rantu also indicate an intention to put questions to the witness.
Thank you. Ms. Ranto? I will park this issue, Mr. Varney. I will park this issue, Mr. Varney, and return to it.
Has the Commission, please?
Ms. Ranto?
Thank you, Commissioners. Thank you, Commissioners. Good afternoon. Mine is just one question to Advocate McAdam, and it's regarding the handover of dockets to the SAPS. The question is, or clarity-seeking question is to establish if I understood him correctly to say that at the time when the dockets were transferred to the SAPS, Brigadier Nell or the brigadier that is not sure of with Senior Superintendent Brits were the ones that would proceed to deal with the matters with the SAPS, or maybe perhaps I didn't get that one clear. I just want to establish that, Chairperson.
Advocate McAdam.
Yes, if I can answer that. The dockets were transferred then to the crimes against the state component of the police, and that was headed by Senior Superintendent Bester, but I'm not sure of the position of the Brigadier, but I know that Mr. Brits did have a contract and he remained seized with those matters even though they had gone to crimes against the state. I had one meeting with Superintendent Bester and Mr. Brits after the dockets had gone back. And then there is record in a task team meeting of 2006 where Commissioner Jacobs put on record that he would need to further extend Mr. Brits's contract.
Thank you. That is all from my side, Commissioners.
Thank you, Ms. Ranto.
I also must indicate, Chair, that Ms. Nkloko advises that they do not have clarificatory questions, but anticipate that they will apply for cross-examination of the witness.
Thank you, Mr. Semenya.
The further conduct of the questioning will be done by my learned colleague, Mr. Soni.
Mr. Soni.
Thank you, Chairperson. Good afternoon to you, Mr.
Good afternoon.
McAdam. Mr. McAdam, when Mr. Ackerman gave evidence, he...
Sorry, Mr. Soni, can you move with the microphone?
I'm so sorry. When Mr. Ackerman gave evidence, he indicated that many of the memos that he submitted to either the NDPP, the acting NDPP, and so on, were in a sense joint efforts by you and him, or solely your efforts. Would that be correct?
The correct position is that Mr. Ackerman would inform me he needs to submit a memo, and then I would do a draft, because neither Mr. Ackerman nor I were computer literate at that stage, but we had an administrative officer who was an excellent litigation typist, so I would stand next to her and then dictate the memo. It would then go back to Mr. Ackerman, and if he was satisfied with the contents, he would then sign it. So there were occasions when Mr. Ackerman did make amendments or corrections to my draft. Also, you'll see on the documentation, I sign on behalf of Mr. Ackerman. That was because, as head of the unit, he was frequently outside the office, so if a memo had to go out urgently, he would then authorize me to sign on his behalf, that we wouldn't have to wait for him to return to the office.
Now, the memos, I take it, would be drafted with the information in front of you. For example, if you were dealing with the PEPCO 3 case or whatever it is that is contained in the memos, it would be based on the information that was in front of you. And can the Commission accept that, to the best of your knowledge, the information contained in all the memos is correct according to the documents that you referred to?
I can only comment on the memos that I myself compiled. I was also often out of the office. Ms. Bokau, a senior state advocate, is also very good at typing, and she would type memos in my absence, or Mr. Ackerman would go directly to our admin officer and dictate Mr. Ackerman's style was to write, and then he'd give her the written thing. So I can take responsibility for the ones that I drafted and were certified as correct.
And certainly those that bear your name would qualify on the basis that we can accept as a commission that what is contained in those memos is correct.
Yes, everything went out under my name and under my signature. Obviously, I accept responsibility for them.
Now, in your evidence today, save for a brief reference to one or two of the memos that are annexed to your statement, you referred to any of those memos?
That was on the advice of my counsel, that he would lead me on specific aspects that he felt needed to be placed orally before the commission. And as far as the remainder, that stood, because I did confirm the correctness of my statement, which included the annexes, subject to those small corrections that we made this morning.
So we can accept that to the extent that you confirm the correctness of your statement, you also confirm the correctness of the memos.
That's correct.
Now, in regard to your statement as a whole, you referred to specific memos, and in addition, the Commission has memos that are not included in your statement. Can we accept that everything that is concerned with your knowledge of the TRC matters is contained in those memos?
This is an unfair question to the witness at this general level. It would be fairer if those memos were produced to him. He's given his general answer, and if there's anything that he needs to clarify, he can deal with it. I understand Mr. Soni may not be able to do that now, but at some stage, if he can produce the specific memos.
Mr. Soni?
Chair, the difficulty is there are memos in different, attached to different affidavits. For example, Mr. Ackerman's affidavit or Mr. Nguka's affidavit and so on. I'm just trying to cover a general proposition. I'm not trying to hold the witness to hostage to what he is saying. I'm just trying to say that when we eventually look at all the information before us, we can accept that Mr. Ackerman has said that he accepts the correctness of what's contained in memos for which he has been responsible.
Yes,
that's the sole purpose of the
I will
question.
allow the question.
Madam Chair, I cannot comment on or accept responsibility in the air on documents that are attached to other people's affidavits without me having had the opportunity to see those documents and satisfy themselves. Why I say that is I have direct knowledge at a certain stage of the forgery of a series of reports by Advocate Ackerman that was done in either 2007. So I don't know if these reports that were attached to these other persons are real, they're signed, whether they are forgeries, whether they are a draft which was submitted before it had been checked by me. And unless I'm given a specific statement and said, look, you read this, confirm it, I cannot assist the Commission further on this point.
I understand exactly what the witness is saying, Chairperson, and this is the approach I intend adopting on this issue.
Yes.
To the extent that it is recorded in a document or memo that it emanates from you, we will confirm that with you by sending it to you and ask you to respond to that. Would that be fair?
That would be a very fair. Yes. I would ask that it be sent to my attorney.
Yes, no, of course. Yes. Now, in regard to the general thrust of your memos, you set out, and we are dealing mainly with the TRC matters, you set out your knowledge of all the TRC matters.
Madam Chair, I can't claim knowledge of all TRC matters, only ones that I dealt with specifically.
Oh, sorry, that I referred to your, in your memos.
Yes.
And the question I want to ask, you know, the purpose of this inquiry is to determine the extent to which investigations into TRC cases were stopped or interfered with.
That's correct.
And the documents you have submitted in your affidavit address that question in part. Am I right?
That's correct.
Now, I think my learned friend Ms. Morocco asked you this. On the basis of your assessment of the documents, it seems from the documents as a whole that part of the reason for the delays in the TRC matters were a lack of resources and a lack of capacity.
That is correct.
And, for example, in particular periods when there were the stoppages brought by the COVID lockdown, that also contributed to the delay.
That is correct, yes.
Were there any other factors that contributed to the delays in the finalization of TRC matters?
Is that from inception? I became basically in 2002 engaged in these matters, which ended in September 21. Must I try and cover that whole period or not?
Well, from 2003, that's the period
yes.
that the
As I
Commission is
said,
investigating.
The refusal of the investigating officer, investigating director, DSO, put an end to all the cases that we wanted the DSO to investigate. We then went to the police. They made a conditional refusal. Now, I can't comment as to whether the grounds put up by the police were valid or not, but I can say when the police said, we're not going to take those matters further, then nothing was done on them, because now both investigative agencies had washed their hands of the matter, and the PCLU had no investigative capacity. It is simply the normal prosecutor who gives guidance but doesn't conduct investigations.
In regard to that issue, it seems when one reads the document and your evidence, and based on your evidence today, it seems that from around 2007 there was an impasse as to which of the two institutions, the DSO or the SAPS, should provide the investigators.
Okay. The issue of refusals by the DSO and the police was in 2003. Now, what happened is Mr. Ackerman is in the best position to tell us what happened, because in February 2004 I was taken away from TRC to work on other urgent matters. But then we come to December 2005, where Parliament approved the TRC guidelines, and those placed a statutory obligation on both the DPCI. No, the DPCI was not in existence then. It placed a statutory obligation on both the police and the DSO to assist the PCLU, and that would be obviously on investigations.
Now, you referred in your evidence today to a gazette. Is that the gazette that contains the prosecution policy, or is there a separate gazette?
No, it's the one that refers to the prosecution policy. I had the gazette, which said that Parliament has noted, and the policy is attached to that gazette. That's the one I had.
And that's the one you were talking about when you gave evidence
That's
this
correct,
morning.
yes.
So when you say that this was gazetted, you are saying the prosecution policy was gazetted.
That's correct. The gazette said that the policy comes into effect, I think, on 5th of December 2004. So it was now a lawfully binding instrument which all government officials would have to comply with.
And the task team that you referred to, and I think you said that too was gazetted, is part of the prosecution policy.
That's correct. That's where it said there the PCLU will be assisted by a single representative of, and it listed the agencies.
Yes. Now, in regard to the evidence that you've given in respect of the memo of the 16th of August 2007, that's the one we just dealt with.
Yes.
Now, the subject matter of this memo took place between 2003 and 2004, would I be correct?
May I just clarify, the decision accepted by Mr. Nguka regarding the ANC leadership was made in early 2004. Now, the letter written by Africa Forum surfaced in 2007. What happened is, after I had made my decision, I then gave a letter to the police informing them of our decision. This was then in, I think, June or July 2004. There was a meeting with Mr. Brits and Superintendent Bester. They told me they're not unhappy, they're very unhappy with my failure to prosecute the President of South Africa. I then said to them, well, fine, give me the docket where all that evidence is contained. They never produced that docket. I then followed it up with Mr. Brits and said, well, where's the docket? Oh, it's now in possession of retired Police Commissioner Mr. van der Merwe. I then asked Mr. Lees to go to Mr. van der Merwe and ask him for that docket. How can a retired policeman have a docket where there is still not a decision against the suspect? You can't do it. Mr. Lees approached Mr. van der Merwe. He indicated he would make material available, but according to Mr. Lees, every time he went back to Mr. van der Merwe, nothing was produced. Then, when the task team was set up, and this would be in about 2006, the police were called to give a breakdown of all outstanding matters that they needed a decision on. And I do have that report they submitted. It listed about 8 cases against the ANC's military wing, where in each case, all the police wanted was a directive as to the need to have further inquests. So the police never reported any new cases where they wanted a decision to prosecute. And those 400 dockets were the whole time under the possession of the Crimes Against the State unit. When the DPCI was set up, it was then incorporated into DPCI.
Those 400 dockets were sent back in 2004, as I understand.
That's correct, yes.
Okay. One of the leaders you mentioned was Sipiwe Nyanda, Mr. Sipiwe Nyanda, who was the ANC military wing commander, or one of the senior members of the ANC military wing.
That's correct.
Were there any ANC leaders, were there dockets opened on any ANC leaders?
No, the dockets were all opened on acts of terrorism, and that was how the police investigation proceeded, that persons were, in certain cases, arrested, convicted, and sentenced. Other cases, there were shootouts between the police and the MK members, resulting in both police and MK members being killed. And then the third category, as I said, the undetected cases. But then people of the very high-ranking people within the military wing did then apply for amnesty. And that was not, I planted a limpet mine or I killed this person. It was my members did it on my instructions. So there they were complying with the requirement of the TRC disclosure in your own involvement in a crime, because they would be guilty of conspiracy, incitement, etc., even though they did not form the physical act. And that's where it came up all those prominent MK commanders did get amnesty.
Those were mainly, as I understand it, the landmine, the cases involving landmine explosions.
The landmine was a specific campaign embarked on by MK. It did trigger a lot of publicity because innocent civilians were killed. There's a case where the farmer and his wife and his young children were blown up. Only, I think, the father survived. But there were also cases where bombs were planted. The Church Square bombing in 1983, the Magoo's Bar bombing, etc. But also within those 400 dockets, there were a lot of acts of sabotage not resulting in any loss of life or injury. I mean, what would happen is in the middle of the night, somebody would plant a limpet mine against a transformer or a railway line. So there would be an explosion, but no injuries or loss of life.
Now, of those 400 cases, were there decisions that they should be prosecuted?
As far as I'm aware, I didn't see any directive at all. The only case where we were approached by the police in 2003, arising from these 400 dockets, was the case of Mr. Blaney. He was implicated in an attack on an elderly couple outside Khampepe, and there had been a warrant of arrest issued for him at the time. He'd been identified by fingerprints, but he could not be traced. And we were then informed that he was now back in the country. So I travelled to Khampepe. I went through all the evidence to establish it was all available. I drew up an indictment, and then Mr. Ackerman did that prosecution, and the person pleaded convict and was sentenced. That was the only case out of all these 400 that the police said, yes, we have a live suspect that we need you to prosecute on.
And the others were because either there was no evidence or amnesty had been granted?
Granted or convicted, or the suspect's dead. Yeah.
Yes.
Mr. Soni?
Yes.
How long are you going to be? We've got to adjourn for lunch.
Yes. Chairperson, I don't intend being much longer, so if you'd give me another 5 minutes, I ought to finish.
Okay.
Now, outside the ANC, were there any other leaders which the TRC unit or the PCLU was investigating?
We had APLA cases investigated as well. And what
Sorry, I didn't hear that.
APLA. I think it's the Azanian People's Liberation Army. That was the military wing of the PAC. So there were cases that were registered, but again, the majority of those cases had already been dealt with, persons arrested, convicted, sentenced, and granted amnesty.
So there were no other...
No, there was one APLA commander who never applied for amnesty. So we had asked the police to investigate, firstly, his involvement in a series of incidents in the Eastern Cape, and thereafter on the St. James and the Heidelberg Tavern cases in Cape Town.
Sorry, before I should have asked you this before I asked you the last two questions. In regard to the 400 dockets, was the last time that you saw them the time when they were transferred from the NDPP officers or the NPA officers to the police?
That's correct, because I can confirm that at no stage were any of those dockets ever submitted back to the PCLU.
And for some reason, it seems that they are referred to as the Visaki.
The
dockets.
Visaki Street.
Or is it the Visaki Street?
That's where the Crimes Against the State unit of the police was located, in the CBD of Pretoria.
So when we are told that there are these Visaki dockets, it is likely that that is what's being referred to, that these are the 400 dockets that were transferred to the Visaki offices of the,
That's
of,
correct,
of
yes.
the police. Okay. The last set of clarificatory issues I need to deal with, Mr. Ackerman, is the complaint of Mr. Kaji in relation to the debt in detention of Mr. Ahmed Timol. Now, as I understand it, and this appears at AD2 of your affidavit, or Annex AD2 to your affidavit. Firstly,
AD2 page?
Page 14544.
I'm just paging, it's 82.
Yeah, so it's page 1454. It's your internal memo to Mr. Leask in relation to the Timol inquest.
That's correct. Yeah, I found it.
Okay. Now, as I understand it, the reason it could not be investigated beyond aside from Mr. Leask is because you could not obtain, or there was no justification or evidence on which you could ask for a Section 28 investigation.
No, it's clearly spelt out in my letter to Mr. Leask that I had then asked him to gather this information, and that would then lay the basis for the application in terms of Section 28. And then when the decision was taken by the investigating director to withdraw the DSO from investigations, Mr. Leask was not able to comply with these directives of mine.
Okay. At the time, though, you had contemplating pursuing a Section 28 application.
That's correct, because, it was conveyed to me that Sergeant Rodriguez's daughter had given a disclosure to a journalist, and if that was confirmed, that would be a key factor to rely on in your application.
Now, did you explain to Mr. Timol, and I'm just asking,
To Mr. Timol.
I'm sorry, Mr. Kaji, that in fact, in order to have a more intense investigation, you would have to make an application under Section 28.
I didn't specifically mention Section 28, but I informed him that all the information that he brought to my attention would be followed up, and we would attend to his matter, which shows in my report of later that month, Mr. Timol's case was reflected as a matter where where representations had been received to conduct an investigation.
And I'm just trying to smooth the feathers. I think Mr. Kaji makes part of the reason Mr. Kaji is dissatisfied is he wasn't aware that there was this particular process that had to be followed before more intense investigations could be done.
Well, I can't comment on that because obviously that's how he would feel, but I deemed it unnecessary to inform Mr. Kaji of the fact that we would follow up all the information that he had supplied to us.
Mr. McAdam, here is a person who loses an uncle, a well-respected teacher from Ruripot, whose death in detention was mourned at the time. Was it not a bit insensitive just to simply say, well, this is how I'm going to do things? I'm just saying, would it not have been wiser to take him into your confidence?
as I said, when I engaged with him, I believed it was sufficient for him to understand we will follow up everything. If Mr. Least had been able to proceed, I'm sure he could have quickly come up with information for me, because we were not only reliant on the disclosure to, Ivor Powell, we were going to interview George Bezos, the researchers were going to establish whether there's additional TRC material, whether the other policeman was involved. Other detainees who are available would be interviewed, and an opinion would be obtained from the chief pathologist.
Now, these are all the matters that you refer to in paragraph 4
That's correct.
of your letter to Mr. Lees,
Yes.
or your memo to Mr. Lees. One of the issues, and I'm just raising it with you again, and perhaps it may ease Mr. Kaji's concerns. He says it is correct that you should have investigated, you should have pursued Mr. Powell or asked Mr. Powell for information. He says a more obvious source of information would have been Mr. Rodriguez's daughter.
Correct. The allegation was that Mr. Rodriguez's daughter had approached Mr. Powell and made a disclosure to him. Now, this is the starting point. Go to Mr. Powell. Does he confirm that? If he does, then that is clear grounds to then do a Section 28. And then once it's been declared in terms of Section 8, you can subpoena the daughter because she may be reluctant to implicate her father and do other information. But what transpired in this matter is that Mr. Lees said, as a result of the refusal by the investigating director, he could not comply with these directives that I had given, but because Mr. Powell had now joined the DSO in Cape Town, he would nevertheless speak to him because he had other work in Cape Town. And Mr. Lees then came back to me and said, Mr. Powell denies it. Here is his newspaper article. It was simply a critique on the magistrate's findings, no reference to disclosures. Because the DSO had refused to investigate, as had the police, we could not take the matter further. And, that is the position.
As I say, and not for you, or only if only for you to comment, Mr. Kaji's point is perhaps Mr. Rodriguez's daughters should have been consulted as well.
Well, he couldn't do that because Mr. Lees could have been instructed by his investigator not to deal at all with TRC matter. So he couldn't go to her, confront her, as he could do if it was a declared investigation. He could approach her. If she refused to give a statement, we could then subpoena her in terms of Section 205 of the Criminal Procedure Act. But those are all duties that can only be done once you have a declared investigation.
And these were the procedural difficulties you encountered in pursuing this any further.
That's correct.
Chairperson, I can just have I have no further questions.
Thank you, Mr. Sono.
Can I just inquire, Mr. McAdam, the decision perhaps not to keep Mr. Kaji or whoever abreast with the latest in developments was not, that decision was not caused by the fact that informing them would jeopardize the investigation. That was not the rationale.
No. The only reason that I only replied to him in February as a result of his reaching out to me was just the turmoil that we were subjected to when, both the police and the DSO refused to investigate. We had all these cases on our plate. Because you'll see there is a memo that Mr. Ackerman, with my assistance, wrote to Mr. Ledwaba in November 2003, documenting all the problems we were facing and appealing to him to reconsider. So it was amiss of me not to keep Mr. Kaji informed because of just the turmoil we were going. It was a very difficult period for us. We just set up. We didn't have proper office space or admin support. We were trying to do justice to all these cases. And you're running around, you're knocking heads. So in the process, I should have replied to him earlier, which I didn't, and I do accept, fault on my part there.
Thank you. Thank you, Chair.
Thank you. Mr. Pana, I have a request by Mr. Vani to postpone his opportunity to put clarificatory questions to Advocate McAdam. I can take judicial notice of the fact that Mr. Vani has been intimately involved in the preparation of the papers in the review application since last week on Thursday. That's when we received our papers in this matter that we are currently engaged in. And that as from Monday and Tuesday, he's been involved in the argument of that matter. In the premises, I don't regard his request to have his clarificatory questions put tomorrow as unreasonable. In any event, Advocate McAdam was scheduled for 2 days, that is today and tomorrow. So I would appeal to you to agree to have Advocate McAdam available for tomorrow for clarificatory questions to be put by Mr. Vani to him so that we can conclude this matter.
Chairperson, we do have one proposal that my team have put up. I just want to put it on the table.
Yes.
Which possibly could accommodate Mr. Bana and Advocate McAdam if tomorrow is inconvenient. We understand that there has been an application to cross-examine Advocate McAdam from the Menzi Simelane team.
Yes.
If that application is to be granted, then we could potentially put out clarificating questions before cross-examination commences on that day, if that proceeds.
Yes. Yes, you may.
Won't be in a position to make a ruling on the application for cross-examination before tomorrow.
No, I will not be in a position to make a ruling with regard to the application for cross-examination until I have received the papers to apply for cross-examination and have applied my mind as to the contents of the application to cross-examine.
Yes. In those circumstances, then, Mr. Vani's proposal is a reasonable one. I understand him to say that we may have to come back if you grant that application another day, and he will then ask his clarificatory questions.
Yes.
Then. We don't have an objection to that.
To that. Advocate McAdam.
Yes, Madam Chair.
You are for now excused as a witness.
Thank you.
There is an application which will be brought before this commission for your cross-examination, which will be brought in due course. You have to be present for that application to proceed to cross-examine you.
So I must be physically when the application is argued before
No,
Madam Chair?
when
it's approved,
the application
and then obviously
has been granted
Yes,
to cross-examine you.
Certainly.
You must be available to be cross-examined.
Yes, I will make myself available.
Yes, you are excused for the moment.
Thank you, Madam Chair.
These proceedings are adjourned until...
Might I just say that we have Mr. Ackerman tomorrow?
Yes.
And that is between 9 o'clock and lunch.
And lunch.
And there are indications that there will be questions put to him through the cross-examination granted to Simelane, DOJ, SAPS, and the MPA.
Come again?
There would be cross-examination granted for the similarly team, the DOJ team, the SAPS team, as well as the NPA.
Thank you, Mr. Semenya.
Chairperson. Sorry,
After
Mr.
that,
Sorry, Mr. Semenya, I thought you were finished. Please go ahead.
no, I was going to say that that would be the business for the day.
Chairperson, just on that question, given that there are 4 parties which to cross-examine Advocate Ackerman, can we propose for the Commission's consideration that the Commission lay down time allocations per party? Because for the moment we have these 2 mornings with 4 parties to cross-examine. It's unclear, given Mr. Ackerman's health, whether he will be able to come back. So we would propose that time allocations be laid down, perhaps equally between the parties for the 2 mornings. And we would recommend to the Commission that the Commission control those proceedings fairly strictly in order to save time. So, for example, if there are questions that are repetitive in nature, that the Commission step in order that time be saved and allow all 4 parties equal opportunity.
Yes.
Thank you, Chairperson.
Yes, Ms. Moroka.
The purpose of an inquiry is to test, the decision in the Amnesty case. We have to probe. We have to test. It doesn't necessarily, and I agree with my learned friend when he talks to repetitive questions. But I think it would be very unfair to say, well, I'm going to give you time and you must divide the time between yourselves. We don't know how many questions are going to be posed. We don't know how long it's going to take. And I think it's going to be put our clients in a very invidious position where we're limited as to time regarding cross-examination. The nature of cross-examination is you're probing. You can't be forced to then be limited to time. We accept that there's health challenges with Mr. Ackerman. We have to be sensitive to that. But I think it is going to be grossly unfair to say I'm going to limit you as to time and how long you take to cross-examine.
Yes. Mr. Vani?
We don't disagree with my learned friend. It's just that these are pretty peculiar circumstances. We would still suggest that there be an allocation of time just so that all 4 parties, that nobody's excluded. If there's a possibility of bringing him back if people don't finish, then that can be looked into. But just bear in mind that we are dealing with an elderly man who is not well.
Yes. I think I may just say, without making a ruling, that we've got to be sensitive to the fact that we are dealing with a person with health issues, very serious health issues, and that the parties must come together tomorrow morning and see how long they each would like to cross-examine him and give an indication to this commission as to how long they each will require to cross-examine. Would not want to put a limitation with regard to the time required for cross-examination on the parties.
That, Chair, we will try to do that, but with a caveat that it might just not be possible.
Yes. These proceedings are then adjourned until tomorrow morning at 9 o'clock.